before the second one, just 3 lines. It appears from the schedule of the instrument locally will be real picture of the suit before this court, and that will help in effective adjudication of the suit. Then appoints and my lord an advocate commissioner. Now, my lord, if my lord takes up my lord order 39, rule 7, my lord, this cannot be done because without serving a copy, my lord, court is not supposed to allow my lord an order 39 rule 7 application unless there is a grave urgency. My lord, kindly takes up order 39 rule 7, read with order 39 rule 8. My lord, has got order 39 rule 8. My lord, order 39 rule 8 subsection 3. Before making an order under rule 6 or rule 7, an application made for the purpose, the court shall accept. So, my lord, therefore, this is absolutely, my lord, against this provision, my lord. And, my lord, this cannot be done at the first day. My lord, we are not in today at all, my lord. We are not in session of the copy of the order 39 rule 7. My lord, when we enter appearance, we find the commissioner has filed a report. We have filed our objection there. My lord, that is what we have indicated in the supplementary affidavit. And till date, that objection is on record, but it has not been taken up or not heard. My lord, we challenge this order, my lord, in this revisional application. My lord, after 1 month of passing of this order, we enter appearance or someone was received by us. My lord, if the appointment itself is bad, the রিটটা জানা আছে কমিশনারের রিট whatever. My lord, objection. Yes. Objection to this. Yes, my lord, that objection, my lord, will find 80. 50. Just a moment. My lord, kindly turns to my lord page 50 of the revisional application that we have annexed. 50. Because we have been, my lord, served with the copy of the report, we have filed it on. My lord, this is something very, my lord, fundamental. My lord, yes. But, my lord, since the report is there, first thing, my lord, I will face hurdle is that is not that report is not. My lord, court, my lord, trial court, my lord, in my respectful humble submission, cannot review its own, or there is no provision for, there is a provision for recall. My lord, then, my lord, I have to file an order recalling that, my lord, directing, my lord, yes. My lord, I have a, my lord, right under 227 to come and challenge. My lord, I did not go for recall. Why did you not come earlier then? Because this does not satisfy me. You filed this application on 16th of April. On that day, you had knowledge about recall. Yes. I subsequently no, my lord. Yes. My lord, there is no limitation in revisional application, but inordinate delay must be, my lord, sufficiently, my lord. My lord, I must express one concern, my lord. For a delay, my lord, can, my lord, an injustice percolate, my lord, into rights? The application of yours also does not whisper about it. It is some sort of a file. The file don't allow it to become final. What will happen? The court will. No, my lord, just, my lord, bear me for a minute. My lord, today, if, my lord, a report is filed, my lord, during, my lord, that is very good, Mr.
but then there has to be some part of the or
But I'm not on the report. I'm on the appointment order itself. Court.
to be challenged within a prescribed period. Years together. After 2 years, you suddenly wake from slumber and then
No.
how many?
Milord, I can only explain my conduct, Milord, in two ways. Milord, first is, Milord, I entered appearance, I immediately took steps. Yes, Milord. Kindly takes up, Milord.
Appointment factor was at least within your knowledge.
Milord, kindly takes up, Milord, from
They'll come before this.
Milord, I have stated in the supplementary affidavit, once I entered appearance, Milord, I was faced with three orders. Milord, one, an application for police has comes in. Milord, I was objecting to that.
Detracts you from filing an application.
No, Milord, I was, Milord, suppose, Milord, I was.
Mr. Chatterjee, the explanation that they took that is why you did not approach court immediately after coming to know about the knowledge, and that was in April 2024. After getting knowledge of the order in 2024, what makes you wait till April 2026? And how would you say that this wait is so justified that even after 2 years, I would intervene? Even if the order is a nullity, there are judgments that even if it is a nullity, it has to be challenged in the right forum, the right court, within the time.
Yes.
I agree that there is no period for limitation, but merely because of that, you cannot come at any time of your choice. And so that you have not come at a time of your choice, but at a time under which you are compelled to come, you have to make out those grounds. Show me that. Not by choice.
Milord, Milord, kindly take some Roman 8. Milord, after this November 2025, Milord, the petitioner was advised by the learned advocate to come up to file and challenge the order in the revisional application. So, Milord, it was after 2025, after Roman 7, Milord, this challenge was made. Now, Milord, be that as it may, Milord, today a point may. Yes, Milord, today I can only justify, Milord, I was not sleeping tight, I was not in slumber. Milord, I am, Milord,
The step to challenge the order by which
Milord, subject to correction. Milord, subject to correction, Milord. Today, Milord, an advice of an advocate, the clients are on the instruction of the advocate. Milord, it is one of the grounds in Milord condonation of delay that the advice on consultation with the advocate, he did it, Milord, after some time. Now, Milord, this being one of the Milord accepted ground. Milord, it's not that I was not going to court, I was taking steps in the trial court, and the advocate, Milord, finally advised me to come before this honorable challenging the order, which caught his eyes. Now, Milord, today, Milord, if I challenge it, Milord, if my lord is of the view, Milord, this is absolutely wrong on the face of it. This cannot be done under law, under any imagination. Then, Milord, today I put this question to myself, Milord, whether this order could be sustained. Milord, I am not today on saying that the issue, Milord, it may go 50% here, 50% there. Milord, I would have said, yes, for delay, Milord, certain 50% has gone into their favor. Milord, this order is absolutely bad on the face of it. Milord,
even if it is a nullity, it has to be challenged within reasonable time.
Reasonable time in respectful humble submission in revisional jurisdiction under 227. Milord, under 227.
27 can't be clear.
Milord, then Milord, I will bring, Milord, the law is very much settled, Milord is aware, to under 227. Milord, even if Milord, while perusing other challenge, if my Lord overgoes to, yes, Milord, my Lord can look into that and Milord rectify that.
But not when you have come. I can rectify it if nobody has challenged. I find it is so illegal, but it has to shock the conscience of the court. I am not yet shocked by this order.
Now, Milord, one judge order, Milord, I have faced it, Milord, in a division bench recently. It was argued by Mr. Mukherjee by saying delay cannot defeat justice. Well, yes. So therefore, Milord, this justice, Milord, which I want, Milord, then under Order 39, Rule 7, there is no question of equity, Milord.
You want delay for delay or you want justice for delay is what is to be tested.
Yes.
Because you are the defendant in the suit.
Yes.
Or you want to take benefit of the delay and then justice for your own self. That also needs to be tested and balanced.
Yes. Today, if this is today, if I had a chance, I could have said that this Order 39 Rule 7 itself is bad because he is fishing out of evidence. I do not get that chance. Kindly appreciates. Today a commissioner comes and files a report. I had to immediately object to that. I objected. Police help comes in application on the basis of injunction. I file an objection. I contest that. The learned advocate says, please go to higher forum and challenge the order. It's the order, the basis on what this police help, this advocate commissioner is coming is itself is wrong. Then, because of this advocate commissioner, today the police help application, has seen a light of the day. If the chronology is seen, for a wrong order, today I have to suffer 1, 2, 3 applications. I put the, if I had come 1 year earlier, my lord would have intervened here and now. So, if that 1 year,
that is a reasonable basis for me not to interfere if you allow it to.
Then, in an injunction case, I can bring that, in where, says that delay cannot defeat equity. There, delay, the equity was, granted on the basis delay cannot defeat justice. Very good. Tomorrow.
Tomorrow, কি বার রে? মানে tomorrow
আমার অসুবিধা নেই, আমি তো খালি জাজমেন্টটা দেখো, আমার সাবমিশন করার কিছু নেই।
Supplementary
মানে ওখানে থাকবে
give it as supplementary.
মানে instead of tomorrow, day after tomorrow, মানে বেলাতে ওখানে থাকবে ডিভিশন।
ঠিক আছে, তোমার সামনে
Supplementary affidavit. So, paragraph and this matter is on second day after.
under the same heading. আচ্ছা, বুঝতে পারবি?
এটা নয় আমার হাতে লেখা। The defendant is the petitioner before your lordship, my lord, in a suit for eviction. My lord, the eviction suit, the plaintiff's sole witness, that was examined on commission. Thereafter, I being the defendant, I also applied for recording of evidence on commission. That application was allowed by the learned trial judge by recording consent of the plaintiff. And my lord, the same learned advocate who, my lord, recorded the deposition of the plaintiff's witness, same learned advocate is being appointed. My lord, there was no difficulty on the, my lord, on the part of both the sides. But kindly takes up the first day minutes where the recording of evidence was being done by the learned advocate commissioner. My lord, page 33 and 34, if your lordship takes up simultaneously side by side, then your lordship, my lord, your lordship knows, my lord, the deposition sheet is a separate sheet prepared even in court, signed by the parties immediately after the recording of deposition. And my lord, the order sheet is being, my lord, prepared separately. And in case of advocate commissioner, my lord, a minutes is being prepared with regard to, my lord, the proceeding of on that day. My lord, the page 33 is the minutes before your lordship, and page 34 is the deposition sheet on the first day of recording witness of the defendant's sole witness. My lord, the chief is being tendered. Some question is being asked at page 34, your lordship has noticed. And page 33, my lord, is recording of the, my lord, minutes on the same day. My lord, the last 4 line your lordship will get, my lord, that the defendant's commission and prayed for time to file the required documents. Last 4 line of the minutes, my lord, and the same is allowed and allowed and considered. and the next date is on 18th of November 2025 appropriate for offer due to the eminent date of CR. So, my lord, this is the deposition sheet is page 34 signed by the parties and the advocate also. My lord, the difficulty arose from the next day. But kindly takes up page 35 now. Page 35 is with regard to the minutes on 18th of November 2025. Yes. Now, my lord, your lordship will get, my lord, 2, 3, 4, 5, 6, 7 line from the top. Has your lordship got it, my lord? 7 line. This sentence starts with the learned advocate for the defendant. After the oath filed a plethora annexures as supporting documents of the suit in her defense. The same is right on commission served upon the learned advocate for the plaintiff. Now the deposition on commission is allowed to be initiated. The learned advocate for the defendant in her initial fact dated such and such. The learned advocate started the tendering of documents, mostly the rent receipts of years to years through the learned through the defendant, such and such. The rent receipts of long years are voluminous, hefty, in quotes, intended in tandem to tender, took a long time of 5:40 p.m. and still enough to be tendered in the next date for the hours. The commission so much is deferred to the next date to be intimated earlier. So, Lord, this is something that proves that on that day, the documents, mostly rent receipts, years together, in a suit for eviction, your lordship knows under the Premises Tenancy Act. Now it is very important thing that this needs to be tendered. That has been tendered, plethora of the rent receipts year to year, recorded in the minutes. But my grievance is that on that day, no deposition sheet is being prepared. And whatever, my lord, I am producing before your lordship, I applied immediately thereafter, since no deposition sheet is being prepared, whether those documents has been exhibited or not, that will reflected, my lord, from the deposition sheet that has to be signed by my advocate as well as the client. That was not done, which prompted me to file an application, because I prayed for that. The learned advocate commissioner refused that. Thereafter, I applied. You kindly change the commissioner, since he is not following the procedure of law. That application, when filed, the learned trial judge directed the advocate commissioner to satisfy the court by filing all the because this was supposed to be, I supposed to get all these things after the entire evidence is being closed. But since the learned trial judge directed, the learned advocate commissioner filed all these things, wherefrom also it evident that no deposition sheet on that day is being prepared, though minute suggests that yes, deposition was done, exhibited documents was being tendered, nothing is being reflected from the deposition sheet. Now kindly takes up the order impugn. I have my application. May I take your lordship first to my application, page 37 of my application, for removal of the advocate commissioner and to replace by someone else. Thereafter, my lord, the learned trial judge asked for a clarification that your lordship will get page 41, my lord, kindly takes up. Yes. Immediately when I filed the application for removal, the learned trial judge passed this order on 6th of January 2026. I am not troubling, my lord, the entirety. Kindly takes up page 42, the operating portion, because this I have already narrated. Page 42, the operating portion, learned trial judge said that having heard and considered the seriousness of the allegation made against the learned advocate commissioner, he, the learned advocate commissioner, is directed to file written objection, if any. Yes, that I have placed already before your lordship. Kindly takes up page 43. Along with this document, he has filed on clarification this proceeding. Kindly takes up paragraph 6 at page 44. It's important. It's his own averment. The documents tendered, has your lordship got it, Lord? On 18th of November 2025, mostly rent receipts were haphazards and took considerable time. It was not possible to break these on time slot. Not a single document of these were taken on deposition on exhibits. Accordingly, next date was decided to afford to local latter to be in convenience and consultation with the learned advocates. Lord, it is something, my lord, it's the horse the law, I must say. If it is not on exhibit, I have a right to challenge that, because your lordship knows if it is kept for export identification, I have to challenge that order also, because it's a proceeding on commission. Now kindly takes up, my lord, yes, by the order impugned, if your lordship takes up, the learned trial judge have not even discussed with regard to this issue. Learned trial judge, my lord, stated everything. My lord, kindly second page of the order impugned, because other part I can place, my lord, before your lordship. There is no difficulty. Second page from the last paragraph, having heard both sides and considered the document regarding proceeding of commission work, it is found that the application for removal of the learned advocate commissioner has been filed on 6th of January 2026 in respect of the alleged incident happened on 18th of November 2025 and 19th of December 2025. This is no explanation regarding delay of filing this application for removal of learned advocate commissioner. Moreover, from the submission of the learned advocate, she's the advocate on record, it is found that it is her own statement that she herself had signed with endorsement seen before the learned commissioner had put the next date on the adjournment application. I am not on that, my lord. This act of casualness is the procedure has to be followed. I am not on advocate, because he recorded the evidence of the plaintiff's witness. So I am not on, and a deposition sheet has to be prepared. No difficulty, my lord. So, my lord, today can't be done, my lord, even before the court. But, my lord, the law is on that day when your minutes suggest that some document at least tendered. So he has to prepare the deposition sheet. My lord, your lordship has to correct the proceeding on that day. Yes, yes. That is the practice. That is the practice, my lord. At least your lordship has to interfere with regard to that day proceeding. So that, my lord, this has to be done de novo, because that day, whatever has been done, I do not know. Yes, yes. No, my lord, yes, it has to be served. Okay. November 18th, 2025. and the defendant. And my lord, no deposition sheet supplied. 11th of November 2025.
Yeah, please, Your Lordship. I was pleased to hear this application on 30th last. And at the midst of a hearing, my lord,
it transpired that service upon the purchasers. Bank was served, bank was represented on the last day. Is required to be made. I have served. May I put in my affidavit of service?
Yes.
Only on record, my lord, for form's sake. Okay. My lord, without much ado, may I hand over the documents which I had placed before my lord on the last date of hearing upon my learned friend appearing for the purchaser, which essentially is the flow chart which I had placed before my lord. May take some time, my lord. I understand, my lord. I understand. I understand. Will it be my lord's pleasure to keep it at 3, my lord? In that case, the board will be over. Right, my lord. So we'll bow down to my lords. But insofar as I'm concerned, my lord, I have made an endeavor to bring everything in a nutshell. Every point. Yes. Very well, my lord. The only, my lord, reservation which I possibly am suffering from some anxiety, that the bank has yet not delivered possession of the property to the purchaser, which was an order passed by His Lordship Honorable Justice Ritapatra Mitra while hearing a writ petition, which arises out of the same action when the Honorable DRAT was not in session. So I was protected to that extent that till the time the appeal is decided, bank will not deliver physical possession to the purchaser. The status is still there till today. DRAT I have lost, hence the instant revisional application. While my lord hears this, they should not convey it to them. My lord, that's the only anxiety, and this will not prejudice any party.
Lordship, as I have received instructions, so Lordship, after the disposal of both the appeals before from the tribunal as well from the Honorable DRAT Kolkata, the petitioner before your Lordship is creating hindrances over there in the process of taking physical possession. They are making encroachment over the land, etc. Moreover, your Lordship, they failed to obtain the. That's one minute. But because we. Yes, absolutely. But the fact remains, your Lordship, with due respect, subject to your Lordship kind consideration, within a minute, that's a very moot question. That maybe I have gone through, not on merits, your Lordship. Prima facie only. Lordship. Lordship, we will not. Yes, sir, we will wait for adjudication by your Lordship.
Very
No
well,
issue.
Then kindly fix a date when my lord hears everybody.
But the only difficulty is if it goes to the.
Let it not go down in the order.
Yes, because it will go down in the order, then your Lordship knows what will happen.
Let it not go down.
We will not. Being an
My
officer
lord,
of the
if
court,
my
we will
lord
not.
records an order till a truncated period so that we again attend.
Yes. But being an officer of the court, we are saying we will not, then we will not.
My lord, prima facie, if I can satisfy yet, my lord. Yes, my lord. Cannot be one-sided. On 13th, as your lordship pleases. That's it.
Lordship. No, nothing will happen. Being an officer of the court, we are saying we will not. Lordship, the matter will retain its position or Lordship is fixing some time?
Yes.
Lordship. Yes. Lordship.
Grateful.
Lordship. Grateful. With a Lordship.
plaintiff is the petitioner, my lord, before your lordship, in a suit for declaration, permanent injunction. My lord, the plaintiff's case is that the defendant number 1 have purchased property from some of the co-sharer who already divested their interest in the suit property by dint of previous deeds. So the vendors of the defendant number 1 do not have any sellable right to, my lord, transfer in favor of the defendant number 1. So no right title interest is being flown by virtue of the impugned deed in the suit. There, my lord, I filed an application for injunction suggesting that, look, this person, upon that alleged deed, trying to make construction, have already rather started construction over the suit property. So injunct him. I got an order of ad interim injunction, my lord, initially. Thereafter, my lord, the defendant number 1 appeared. And subsequently, that are the order sheet. Lord, may I just hand over before your lordship the entire order sheet, bunch of order sheet till date, just prior to the impugned order. Lord, thereafter, the ad interim order, after the ad interim order was passed, Lord, the defendant number 1, Lord, from the order sheet, Lord, I'm sorry. Lord, order number 6, your lordship will get, Lord, the defendant number 1 appeared and filed also. Lord, the prayed for written statement and written objection to be filed. Thereafter, my lord, he disappeared. Since the appearance was not there, my lord, on behalf of the defendant number 1, by the order number 11, your lordship will get the ad interim order was made confirm, absolute, and the suit is being posted ex parte against defendant number 1 by order number 11. Now, my lord, I filed an application under Order 39, Rule 7 for holding a local inspection because I cannot, my case is that in spite of subsisting order of injunction, the person who is constructing, he is disobeying the order of injunction and still making construction. So to get that picture, to bring into the record of the court, a local inspection is necessary. I applied for local inspection. That is at page 28 of my lord's brief. Basically, my lord, the schedule is at page 30. Point number 1 is the important schedule. Page 30, page 28, my lord, my application starts. Page 30 is the schedule. Point number 1 is important, my lord, that because, my lord, I want to bring into the notice of the court that what is the present topography of the suit property, whether any construction is ongoing over the suit property or not. But whatever that has been done, that has been done. But if I want to stop it, I have to bring the picture. What is the position of the suit property as on this day? What is the nature and extent of construction as on this day, so that it can be protected. Immediately thereafter, my lord, along with this application, my lord, page 32, I applied for also, my lord, 151 for, my lord, implementation of the interim order of injunction that has been made absolute, my lord, through police help. My lord, it's interestingly, my lord, I forgot, my lord, kindly takes up now, my lord, the ad interim order which was initially granted. It is page 25 of my lord's brief. My lord, page 25, just the operating portion. My lord, your lordship will get after the injunction is being, my lord, passed. The OC Jaipur PS is directed to look into the matter so that the spirit of the order would not be hampered and file compliance, if any, onwards incident occur. So this is also in aid of me. My lord, that has been done. Still, my lord, the disobedience is there. That's why, my lord, that prompted me to file these two applications, local inspection along with police help. Kindly takes up now page 35. Yes. When, Lord, he disappeared because he knew, Lord, he is merely making construction disobedient to the order of injunction, injunction. When I filed these two applications, he was a fence sitter. That's why, Lord, he immediately took out an application for ex parte vacating and also for acceptance of his written statement on the day of passing of the impugned order. And all this application, interlocutory application, Lord, the learned trial judge taken up together and the order impugned is being passed. Lord, kindly takes up page 35. What is the explanation he has provided? বিচারপতি উক্ত মোকদ্দমায় প্রতিবাদী কার্য উপলক্ষে রাজ্যের বাইরে থাকায় তাহার নিযুক্ত উকিলবাবুকে অত্র মোকদ্দমা দেখাশোনার দায়ভার অর্পণ করিয়া থাকেন, কিন্তু তাহার নিযুক্ত উকিলবাবু অত্র মিলট পেজ 35 মিলট ইটস দি এক্স পার্টি ভ্যাকেটিং। ইয়েস, উকিলবাবু অত্র মোকদ্দমার বিষয় সম্বন্ধে এই প্রতিবাদীকে সঠিকভাবে গাইড না করায় যথাসময়ে প্রতিবাদী স্টেপস না লইয়া ও জবাব ও আপত্তি দাখিল না করিতে পারায় হুজুর দ্বারা আদালত পূর্বক প্রতিবাদীর বিরুদ্ধে গত ইংরাজি কাইন্ডলি মার্কস মিলট দিস হ্যাজ বিন ডান ex parte on 30th of November 2024 and the impugned milord this application is being filed milord in 6th of January 2026 on the day of passing of the order impugned, 6th January 2026. So, milord, this is the cyclostyle application is also milord in respect of page 37 for acceptance of written statement. This is ex parte vacating and this is acceptance of written statement, page 37. Now, milord, may I take your lordship to the order impugned? Milord, order number 15. Order number 15. Milord, on the day when these two application of the defendant, ex parte vacating and milord the acceptance of written statement was filed, the learned trial judge taken up that application first without giving me an opportunity to file even written objection to that. And what has been done, milord, kindly see. Milord, may I place the plaintiff and the defendant number 2 files Hajira? Has your lordship got it, milord? The plaintiff filed an adjournment petition for evidence together with a petition and summons addressing Pradhan Kanla Gram Panchayat because my evidence was already started, PW1. The plaintiffs also filed a petition praying for police help so that the injunction passed by this court may not be flouted. The defendant number 1 files ex parte vacating petition together with the written statement supported by affidavit and the prayer to accept the same. The plaintiff also filed a shifting back petition today for shifting the case record from PH board for hearing of the above petitions. Having heard the parties, the record is shifted back to the PH board. From the PH board. At first, the ex parte vacating petition together with the acceptance petition for the defendant number 1 is taken up for hearing. It has been submitted by the learned advocate of the defendant number 1 that earlier conducting learned advocate could not guide him properly, and as such, the suit runs ex parte against him. There was no latches on the part of the defendant number 1, and he is always ready to proceed with the suit. Plaintiffs raise objection and stating that the grounds mentioned in the petition are not sufficient, and he is intentionally dragging the suit. Considering the above submission and the evidence and the effective consideration, the defendant number 1 be given an opportunity to place his defense. As such, the ex parte vacating petition is allowed as every controversy should be disposed of finally after giving opportunity to all the parties. So, milord, this has been done in a cursory manner in my respectful submission, but I am even not on seriously on this. Kindly takes up not their latter portion of the order. Let the ex parte proceeding, milord, is vacated. Hence, the written statement of the defendant number 1 is hereby accepted. Both local inspection commission petition and the petition for police help are taken up hearing conjointly. It has been submitted by the learned counsel for the plaintiffs that in spite of having knowledge of the temporary injunction with respect to the suit property, the defendant number 1 has started to make construction of a multi-storied building thereon. They are on the B schedule property being the part of the A schedule property. As the plaintiff number 8 being the Todbitkar of this case was out of station, he informed the matter by mail to the police to take necessary action, and later on the police stopped the said illegal construction, but also advised the plaintiff to bring necessary direction from the court for police help. So it appears from the contention of the plaintiff that no work of alleged construction is going on. Even the order itself is a direction upon the parties and the authority concerned to comply the same. No specific direction is needed. Hence, the petition for police help stands rejected. Now it is Now it is considered by the plaintiff that in violation of the injunction of the defendant number 1 is making construction, and thus to prove the said fact, making of Pakka building as well as bring to present true picture of the said under consideration building an advocate commissioner is required to be appointed for holding local inspection with respect to A and B schedule property. No doubt a local inspection commission is appointed by a court primarily to collect evidence or facts are difficult for the court to assess directly or to conclude the issue and the controversy in between the parties. When the physical presence of the location is crucial, local inspection is mandatory, being the eyes and ears of the court. Here in the case in hand, the plaintiff seeks for local inspection to prove the violation of the injunction order, if any, by the defendant number 1. The plaintiff failed to convince how could the commission help the court to conclude the issue between the parties, and then let it reject. That in my respectful submission, these two, in tandem, I need not come one after another time, to before the court by filing one after another interlocutory application to resolve the issue, because whenever they started, then again this issue will come up. Again, I have to file this application. I filed the application so that once for all, and it's my suit, it's my suit, your lordship, because it's the evidence. It has been without local inspection. If it is next date, বলতে পারবেন? That I don't.
statute.
Yes, my lord, I am appearing for the petitioner. My lord, I am the defendant, the judgment debtor in the suit. Now, the suit was filed for declaration and injunction. Now, erroneously, we have mentioned in our petition for recovery of khas possession because in the judgment, the word recovery of khas possession was there. That is my mistake. Now, suit was decreed against us. Execution was filed. We filed section 47. 2 points were raised that one of the defendants, defendant number 6, Ahera Bibi, was expired during pendency of the title suit. She was never substituted nor expunged. She was expunged at the time of execution proceedings. So the degree becomes nullity in the eye of law. And another point is that, my lord, that the 105 shatak of land was in the schedule of the plain, out of which one is 309 dag number, in which is a graveyard that was totally suppressed by the plaintiff. Now, at the time of execution proceedings before the learned trial court, an application for, my lord, examination of commissioner was appointed, commissioner advocate, that was also turned down, and these points was never considered. If your lordship kindly comes to my 47 application, which starts at page 40, and the relevant part I am placing page 41, your lordship. Kon para? Yes, para 3, my lord. Your lordship got, my lord. শহর আলী মন্ডল 45 শতক জমিতে সত্ত্ব দখল ভোগ পরিচালনা করিয়া আসিতে থাকাকালীন 5 পুত্র সাচ অ্যান্ড সাচ। নাও কাইন্ডলি সি নূরজাহান কন্যা নূরজাহান মন্ডল এবং স্ত্রী আহেরা মন্ডল ওয়ারিশ রাখিয়া পরলোক গমন করেন, কিন্তু প্রতিপক্ষগণ জারির মোকদ্দমায় ডিগ্রি দা শহর আলী মন্ডলের সমস্ত ওয়ারিশগণকে করেন নাই। নাও ইউর লর্ডশিপ স্কিপ দিস প্যারাগ্রাফ অ্যান্ড কাইন্ডলি কাম টু, my lord, the next paragraph 4. প্রকাশ থাকে, your lordship kindly see the last portion of paragraph, প্রকাশ থাকে জারির মোকদ্দমায় 6 নম্বর দায়িক অনেকদিন আগেই my lord, paragraph 4, the second paragraph of paragraph 4 that starts with প্রকাশ থাকে যে, your lordship got, my lord, paragraph 4. Paragraph 4 starts with utto jarir mokoddama. Yes, I'm grateful. Now, your lordship skip 3-4 lines. মানে the paragraph starts প্রকাশ থাকে যে, your lordship, yes, জারির মোকদ্দমায় 6 নম্বর দায়িক অনেকদিন আগেই পরলোক গমন করিয়াছেন, কিন্তু ডিগ্রিদার সেই কথাও আদালতে গোপন করিয়াছেন এবং 6 নম্বর দায়িকের সমস্ত ওয়ারিশগণকে পক্ষ করেন নাই। Now, the next paragraph is my second submission, that ইতিপূর্বে দরখাস্তকারী অর্থাৎ জারির মোকদ্দমায় দায়িকগণ টাইটেল সুটের জবাব দাখিল করিয়া প্রকাশ করিয়াছেন নালিশি 309 নম্বর দাগে শহর আলী মন্ডলের 45 শতক জমির মধ্যে একটি কবরস্থান রইয়াছে। That is there. That was completely suppressed. We have mentioned, it is not that it is for the first time. It has come into the execution procedure. Now, your lordship kindly come to the plane where your lordship will get, my lord, that the defendant number 6, my lord, though expired on 2012, 2011, my lord, kindly see page 12 of the plane. The left portion, Mosaret Ahera Mondol, left portion of the plane, just in the bottom, my lord. Page 12, my lord. The left portion in the bottom. Left hand side is written, my lord. Mosarat Ahera Mondol, Shami Mito, Shohor Ali Mondol. Your lordship got, my lord? In the left, in the, yes. Now, in the plane, the, yes, Ahera Mondol, my lord, according to us, was expired, my lord. Now, the later on, after the degree, I'm coming to that. I'm grateful to your lordship. Now, my lord, kindly come to the degree, that is page 36. 36. Your lordship, জাজমেন্ট গুলো ব্রেক করে রাখো। দাঁড়িয়ে আছে পেজ 36 kindly see my lord column 6 Mosared Ahera Mondol Shami Shorali Mondol. It was not, my lord, substituted before passing of the degree. It was, my lord, expunged at the time of execution proceedings. So the degree, according to my respectful submission, is a nullity. And so far the graveyard is concerned, my lord, it was suppressed. As your lordship is well aware, my lord, that it is a settled principles of law that executing court cannot go beyond the degree. But if the degree is a nullity or it is passed on the basis of fraud, then certainly the executing defendant, mother. Only I will be beseeching for a, my lord, serve the copy, my lord, because as an officer of the court, I must be candid before your lordship that possession has also been delivered on 18th of 11, and the impugn order is at, my lord, 15/11/25, order number 22. These points were raised, and even the appointment of examination commissioner, advocate commissioner, to examine the veracity of truth, that whether there is graveyard or not, that was also negated by the learned trial judge, my lord. Deeply obliged.
Just got the order because
No, it is
it is
not
one
yet
thing.
uploaded.
If the matter is simplicity urgent, then I'll maintain this revision. No, but the judgment is delivered. If the judgment is delivered, that may not be. But if it is a mere order for transfer to another bench, so then the order remains. No, the order is she's saying is passed.
Passed, but it has not yet been uploaded in the CIS, my lord. My lord, and the next date is fixed on the 16th of April for final hearing of the appeal.
This is the way, well, we are feeling that this is a concerted attempt to then come and say when we file the revision, appeal is fixed for hearing.
My lord, on the last occasion,
I have a right to say that my order should be stayed when I move the revision. Once it was no order. Second time, when your lordship's specifically order was made that you give an interim order, lower court records had to be produced. file a fresh revision, then immediately they make it CAV. Now I'm told it has been stay petition disposal appeal fixed on the 16th. If this is a way, if this is a concerted effort because somebody is involved, that to make sure I can't move my revision, because I have a right to move my revision from a refusal to grant stay, irrespective of whether each time it is adjourned for 2 days, things like that.
We don't know.
She's saying it's been fixed for appeal hearing on 16th.
My
That
lord,
is
on
what
the
she's
last
saying.
occasion, written notes were submitted by both the parties and the judgment has been delivered, but it has not yet been uploaded in the CIS. It is actually showing that for next for appearance and appeal hearing on 16th as per the CIS. My lord, and the judgment has already been delivered, but we have officially heard about it, but we have not yet received the copy of it.
Appeal hearing on 16th. So I
The
will.
stay has
So I will
stay
move the
application has been-
revision has possibly no stay. So when I move, I am earliest I can be it can be listed will be on either the 10th or 16th. They will come and say the appeal is being heard now. But this is not the well, I have a right to have revision. Well, I'll have to file a fresh revision, no doubt. If there is an order passed, that the appeal be heard tomorrow or day after. I'm not granting any stay. Lordship, kindly then allow me to move my revision and let them not come and argue that since the appeal is fixed tomorrow, I will. Well, this is my apprehension. Well,
Keep it on 16.
then can I make a humble prayer since my revision is there that the order since is passed, that the order be made available immediately because it was passed apparently on the 6th on Monday. Order is not being made available. They know what the order is. We have no idea. Order should be made available immediately. No, order is passed because
Yes,
lower
my
court
lord.
practice, lower court.
Stay application was heard and order was passed against the stay application. So the main appeal hearing is pending on 16th.
So, well, order normally lower courts they pass. Tomorrow it will be there.
Hopefully.
Hopefully. Grateful to God.
I'm grateful. Yes, my lord. I'm grateful.
Well, this is my application. Well, the issue was the application under Order 6, Rule 17 before the learned court below. Malad kindly takes up the order dated order number 8, my lord, 26th of November 2025. Yes, my lord. Yes, my lord. I am tendering my apology, my lord. I was not there. Yes, my lord. Maybe, my lord. Maybe, my lord. My lord, my respectful submission would be, my lord, at the time of amendment issue, my lord, the court can decide the main issue under bar order 23 rule 3A. Yes, my lord. Yes, my lord. But my lord, my respectful submission would be, my lord, at the time of amendment stage, my lord, at the very time of threshold, my lord, that cannot be decided whether the main issue is maintainable or not. Yes. Yes, my lord. Yes, my lord. But my lord, there are some judgments, my lord, at the time of very threshold, my lord, that cannot be. Yes, my lord, that cannot be decided. Yes. Yes. But in respect of that, my lord, my answer will be that has to be decided at the time of framing issues or after the trial. Because, my lord, if the amendment is allowed, my lord, that cannot be harm anyone. There is an opportunity to file written statement in respect of the defendants also, my lord. My lord, no, that is not a similar amendment. Yes, my lord. I bow down, my lord. Yes. It is something is very new. There is no doubt, my lord. But, my lord, there is one judgment. May I show, my lord? Yes, my lord. Yes, my lord. I am trying my luck. Yes, my lord. There is a judgment, my lord. Measures Revajadu Builders. I am handing over. My lord, I am not reading entire judgment, my lord. Kindly takes up, my lord, paragraph number 63 and 64. I am reading, my lord. The court has very wide discretion in the matter of amendment of pleadings, but court's power must be exercised judicially and with a great care. What I have submitted, my lord. The Ganga Bai's case, this court has rightly observed the power to allow an amendment is undoubtedly wide and may at the stage of appropriately exercised by interest in the justice, the law limitation notwithstanding, but the exercise of so far reaching the discretionary power of the governed by judicially consideration and wider of discretion, greater ought to be the care and circumstances on the part of the court. The cost 65. The court have consistently laid down the unnecessary delay or inconvenience. The opposite party must be compensated with the cost. The imposition of the cost is an important judicial exercise, particularly when the court deals with the case of amendment. My respectful submission would be, my lord, in respect of that the impugned order effectively rejects the pleading on the ground of maintainability. But issue was whether the court has power to exercise its order 6 rule 17. Well, page number 42. Yes, ma'am. And true copy, my lord, page number 47. It is written in Bengali. Well, page number 47 is a translated version. No, ma'am. No, my lord. My lord, give me some time so that I can get the certified copy of this application. Yes, my lord. Give me some time so that I can bring. My lord, 9 to 10 days that will take now. I'm extremely grateful.
This is my application for expeditious disposal and a time-bound disposal of a suit pending since 2017 before the 6th Court, Alipur. The suit
14 হ্যাঁ
13,
13 না হলো
13.
13 হবে না 13 13 make please your lordship হ্যাঁ 13 তো the code below in a matrimonial suit award an alimony which is exceeding his jurisdiction without any record, particularly without an affidavit of asset filed by the wife. And any affidavit is asset, this one. And only application has filed under section 24, so many allegations. And in affidavit also stated that he is to my best of my knowledge. But how should know? May I read the alimony first? Whatever he has did, so many allegations made in the application only, and the court has taken dispatch without any basic document.
Stay on.
Huh? Without affidavit asset, without any affidavit asset. No, and the court has not stated that his file. No, not following the procedure. Both sides has to file affidavit assets and documents relied upon. But husband had filed affidavit assets, documents filed, all documents. But wife neither filed any documents, only the application for section 24 without so many allegations, without any. He has stated that I have got landed property, no particulars given. I have a business, no particulars. I'm section 24, page 16. Page 16. On 16. So many allegations.
Stay on 6.
Huh?
Stay on 6 days.
And he has stated we have dowry, molestation, everything. But he only
Stay on 6 days.
no, section 24 file of acid yes, acid is acid to কোথায় কত টাকা যাবে 27 onwards. 27 onwards is my assets. But wife has to file any affidavit.
Yes. Yes.
Yes. No. What?
Pro bono. Stay on 6 days.
Only what he has stated so many allegations, dowry, molestation, everything. But he has no. I only 6 days he has lived at matrimonial home. Or only interim stay only. No, no, I will not, no, 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 nowadays, you know, you were unemployed. Huh? Yes, I'm ready to face. I'm ready to face. I'm not, yes. So many graduates presently are unemployed. They are getting only 150 rupee alimony from the, yes, I'm grateful.
Yes, my lord. The petitioner, defendant, on rejection of the application under section 17(2) of WPPT Act 1956, I have come up for revision. 17(2) of WPPT Act 1956. That is rejected. Question of rejection, I have not heard till my practice. Rejection of the application 17(2).
Initially, it was suit of 1983, subsequent renumbered. Now, Mala, the nature of the suit has been changed by way of amendment. Now, this is a suit for eviction of a licensee.
Then how the question of 17(2), rejection of 17(2) will arise?
Not maintainable.
At the time of presentation of the plaint, initially the suit was under the provision, under the provisions of West Bengal Presidency Act. No, they say may be permitted to submit the application when they filed the suit in the year of 1983. According to the provision of law is this, that an application under section 17(2) is required to be filed by denying the relationship of landlord and tenant. Yes. Licensing. My lord, only one thing. Your lordship, kindly come into the judgment of the impugned order. Kindly, my lord. The trial court has raised this point. This court thinks the defendant has avoided the mechanism to acknowledge and pay the admitted rent 17(1). How the question of admitted 17(1)? How the learned trial court has opined when the plaintiff confessed that at this stage the suit is not for West Bengal under the West Bengal Presidency Act 1956. At this stage, suit is for eviction of a licensee. Then his submission, your lordship may take a note of it. That a suit is no more.
My lord.
Yes, the question of 7(1).
Just let me clarify, initially.
আমার কাছে নেই
Yes, আমার কাছে আছে।
আমার কাছে নেই দিল না আমি প্ল্যান
না, আপনি অ্যানেক্স করেছেন।
আছে প্ল্যান
Yes.
না আমার নেই মনে হয় করিনি আমি মনে হয় করেছি
If you lost him, let me place the facts. Just kindly have a look at page 15. Page 15. Paragraph 2A. Prior to that, if you also kindly have a look at this. The application for amendment was allowed. They have challenged. Yes. They have challenged the set in revisional application, and that has been confirmed. That order has been affirmed by this honorable court.
That is not the problem. Problem is the you.
And now kindly have a look at page 15, paragraph 2A at the bottom.
That cannot be approbate or reprobate.
I'm coming, my lord. In 1977, my lord, I filed a suit for declaration of my right title interest over the property in question, and for declaration that the defendant is a tenant under me, and for recovery of area rent. In the said suit, my lord, the learned court below was pleased to hold that, my lord, plaintiff have right title interest over the property in question, but I failed to prove that there is relationship of landlord and tenant between the parties. If you will also kindly have a look at the order passed in earlier suit, kindly have a look at page 42. In the earlier suit, my lord, wherein, my lord, I paid for declaration of my right title interest over the property in question. Page 42, my lord, issue number 3, just 4 lines from the top.
And the issue number 2.
Coming, I am coming. Issue number 3, my lord, has the plaintiff any right title interest in the suit property? Decisions with reasons. In order to prove the ownership of the suit property, the plaintiff number 2 sale deeds dated such and such, VD Exhibit 1 and 1A, a deed of agreement dated 9/1/1964, Exhibit 2, stood established, my lord, at page 44, my lord. Yes, my lord. The plaintiff has acquired right title interest in the suit property, and the issue is thus affirmed accordingly. Now, my lord, so far the issue number 2 is concerned, my lord, whether the plaintiff, there is relationship of landlord and tenant between the parties. And the next issue, my lord, 1, 2, 4, and 5 were dealt with by the learned trial court, my lord, simultaneously. And the learned court below was pleased to hold, my lord, there is no relationship. Kindly have a look at page 52. Page 52, in the premises, I hold that the suit is maintainable, but the plaintiff has failed to discharge his honors, and the documents Exhibit 5, 8, 9 do not carry any presumption of creation of tenancy. The plaintiff also failed to prove that the defendant is defaulted in payment of rent, and also period of default and the quantum of arrears, though the defendants also claimed adverse position. But to corroborate evidence available to prove the fact, in the absence of a case of ouster of disposition against the true owner, his position cannot be stated by as adverse position. The defendant has not filed any document claiming his independent title in the suit property. When the plaintiff has been able to prove his title to the suit premises, the possession of the defendant in the absence of any express contract for use and occupation of the suit premises, in my opinion, is permissible. Not for eviction. I have paid for declaration of my right title interest over the property in question. I have paid for declaration that the defendant is a tenant under me, and for recovery of area rent. In the said suit, my lord, this order was passed that it was held that I have right title interest over the property in question. This judgment was passed in 1994. Prior to that, in 1983, I filed a suit under the West Bengal Premises Change Act 1956. Praying for eviction on the ground of default and reasonable requirement. Now, my lord, after this amendment, after this order, I took out an application for amendment before the learned court below. The learned court below was pleased to allow the said amendment. That order was challenged by my adversary before this honorable court, and that has been affirmed by this honorable court. Now, my lord's suit is for eviction of a licensee. Now, under this suit, at this present juncture, the application under section 17(2) is not maintainable, because the 17(2) is maintainable in a suit when any eviction proceeding has been initiated under section 13 or any of the grounds as enumerated under section 13. Now, my lord, my suit is for eviction of a licensee. In such a suit, my lord, the application under section 17(2) is not maintainable. On the privacy, my lord, it is not maintainable. And my lord, the Honorable Apex Court, my lord, in a judgment, my lord, wherein, my lord, the plaintiff filed a suit for the eviction of a tenant, and if it is found that the plaintiff has right title interest over the property in question, but failed to prove the relationship of landlord and tenant, in that event, my lord, the court has the power. Yes. So, earlier suit 1977, and the present suit is 1983. Now it has been renumbered. My lord, in 1966 Supreme Court, my lord, it has been held, my lord, there are similar circumstances. The suit was filed for, my lord, eviction, claiming the defendant as a tenant under him. In such a suit, my lord, the right title interest of the plaintiff was established, but the plaintiff has failed to prove that, my lord, there is relationship of landlord-tenant. In that event, my lord, court is not powerless, my lord, to grant, my lord, relief to the party. The Supreme Court says, my lord, in such a situation, my lord, court can grant decree treating the defendant as a licensed or permissive occupier. If you lordship, my lord, rely on this judgment, my lord, that is reported in, my lord, 1966 Supreme Court 75. Yes, ultimate conclusion is right, but the reason is something. Yes.
By virtue of the amendment filed by the defendant, because they are not pressing. That they have filed a suit. Now the suit stands as suit for eviction of licensee on eviction grounds. Yes. No more. Yes, my lord.
No, my lord, both of them has accepted the judgment, and it is stop. Yes, my lord. My landed friend claimed adverse possession in the said suit, in the earlier suit, and that has been negated. Now he has not. He is also stopped.
My lord, my submission only remains. Kindly, my lord, page 68. Page 68.
Paragraph 12, 13, and 14.
No, sir. Page 68. Your lordship finds from the judgment passed in the earlier suit, that is title suit 23 of 77, last portion, neither parties have prayed for permissive possession or any other thing. She said, I have filed a suit for a decree of adverse possession.
Now my lord is also stopped from taking this because in the said suit, my lord,
that present. That no. What my defense is in the suit? Yes, my lord. But only one thing. What the landed trial court has said, that admit the word admitted, and why the defendant has not paid the amount of monthly rent under the provision of 7(1). For that reason, I am referring a judgment. Kindly, my lord, page 39. Para 39. Sorry, my lord. However, even proceeding on such demise, the cardinal basis of the judgment rendered by the division bench in Synthetic Plywood versus Industries Private Limited, 1998, Volume 2, ICC Cal 280, did not change the amendment of statute, just as in Section 17 of 1956 Act. In Section 7 of the 1956 as well, the language used is tenant and not dependent on such premises. Now, as the trial court used the word that I am avoiding to pay the rent, for that reason you cannot avoid by filing an application under Section 7(2). For that reason, I am citing this decision.
One thing, just one thing. Can you have a look at page 53?
So, just a minute. So, for the ground, they have alleged licensee. I have the defense. Yes, yes, yes. For that reason, they just a minute. They cannot in two ways, tenant and also. Yes, yes, my lord. Yes,
Kindly have a look at page
Yes, ma'am.
53 of the revisional application. 53, my lord. First line, my lord, though the second line, the defendants also claimed adverse position, but the corroborative took. No, 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 no,
That's true.
no, no, no,
That is no, no.
no. Kindly have a look at this. The court has
No,
in
no.
earlier suit in 77
That
suit.
question cannot be. That question cannot be here. Yes, in that case, there.
And my lord, this is
Trial-
the judgment of the Honorable Apex Court, my lord.
Trial.
A judgment.
By the order, you cannot seek for order that my suit for the adverse person will go infructuous. That cannot be.
By once.
Yes, yes, my lord.
Once.
Yes, my lord. Yes, yes. Yes.
And my lord, once my lord, an order is passed, and unless and until my lord, that is my lord, assailed before the higher court, my lord, that is binding upon the parties, my lord. To that event, my lord, the Honorable Apex Court says so. Paragraph 7 and 8. Eight to this. Yes, that is binding upon these parties. My lord.
Three of 83. 23 of 77.
No, that was filed by the opposite party hearing.
Against the petitioner. For declaration injunction.
Page 42, my lord.
Petitioner interest. Petitioner interest.
And for
Declaration for,
declaration that the defendant is a tenant under him and for recovery of area rent.
no, dismissed. Dismissed on contest. Page 54, page 54. Page 54, that the suit B and the same is dismissed on contest with cost.
So dismissed, but it was held that the
No,
plaintiff has
that
acted
is not.
interest for the
Suit is
property in cost.
not. Gone. So gone. Suit totally dismissed.
Anyhow, but the
No,
declaration
suit
has,
is totally dismissed.
my lord.
I appear for the petitioner, my lord. Lordship wanted me to serve, my lord, the auction purchaser. Nimesh the ki opposite OP2. My lord, OP2 has been served, so he's. My lord, I am aggrieved against, my lord, first the recovery officer's order against which I preferred a challenge before the DRT PO in a section 30.
Section 30 appeal is pending.
Gives me some protection, my lord, sends us to there, I am okay.
May I just indicate on that case, may I just indicate one thing?
No,
they are stopped to challenge the physical position, my lord. Why I am telling your lordship?
Look at the conduct. Look at the conduct of the bank. Look at the conduct of the bank.
My lord, they have. Yes, please.
No, it's with receiver now. I have given possession to receiver.
Yes,
Receiver has not given possession to auction person. I am not.
Yes.
So, my lord, I wanted an interim relief. My lord, the point is, I get what your lordship. Yes.
Will hamper our case.
Lordship tests that. No, appeal is not yet ripe for hearing. It is the interim application which is right.
So the next date is.
That is, my lord, my appeal before the PO. That is on 24th April.
24th April.
Yes. And there is a application, my lord, for hearing, my lord, tomorrow at the instance of OP2, who is the auction purchaser, to, my lord, get an order of possession from the receiver to him to complete. My lord, why would the courts, my lord, if I may put my submission in the form of a question, why would no court, my lord, decide this issue of redemption of mortgage? My lord, I am on a very simple. My lord, at the interim relief, my lord, stage, my lord, if I can satisfy that the bank had the entire money. My lord, kindly visualizes a situation tomorrow. May I suggest something workable? Which is, my lord, going through my mind. My lord, whatever is the position, let that status quo prevail. Direct the PO to hear the appeal, including the point of redemption. My point is very simple. On the date when the auction purchaser puts in the money, last 75%, that is 27th of January 2025. Thereafter, I put in the balance money under the decretal sum 1.41 crores, which satisfies not only the decree, but something beyond that. That is on 18th of February 2025. Sale certificate not issued. Then, now, my lord, the only thing that was to be tested by the PO or the DRT was whether the courts would allow the sale to continue for a sale certificate to be issued and ultimately possession to be given. According to me, my lord, and I am armed with judgments, both, my lord, of SARFAESI Act, very recent judgment, even in a SARFAESI proceeding, 13(8), my lord, staring at the face of the, my lord, borrower, still, my lord, presided over by Justice Dipankar Datta's bench, my lord, said that no, that right of redemption will be, my lord, still available to a borrower. So, upon the sale being set aside. So, my lord, what I am, so, yes, that will be considered. My lord, I am not seeking an injunction per se like that. I am only saying preserve the subject matter today and direct the PO to hear it. My lord, tomorrow, if Mr. Mishra's client ultimately gets the property, the possession, he has the sale certificate now, he gets back possession. My lord, there is no embargo for him. My lord, to again transfer, again encumber. My lord, there may be 4 transfers thereafter before, my lord, the PO finally hears. Why would the courts, my lord, not It can be, my lord. That is one way of looking at it. I am not saying it can't be. But, my lord, if I am entitled, if I can prima facie satisfy your lordship, I would invite your lordship not to shut your lordship's eyes to this fact that payment was made. My lord, this is the highest right which a borrower has, a right of redemption. The borrower is only saying that he has paid the entirety of it. Bank will not be, my lord, in a position to realize that, my lord, excess amount which he has received from the auction purchaser. It will come back to me. My lord, I am saying, my lord, bank has received, because bank is not concerned with, my lord, the property. Bank is only concerned with the money. My lord, kindly, I have prepared a short list of dates. Maybe list of dates.
May I just indicate one thing, the OTS proposal has been rejected long back. That is on record. Subsequently, they have again, my lord, deposited
These dates, my
money
lord,
to their
kindly
donor.
consider these dates. Lordship will understand my lord predicament. Just, my lord, Mr. Chaudhary is leading me.
My lord, I'll be very brief. I am conscious, my lord, that we have lost into Fora Bureau
At the interim stage.
at the interim stage. My lord, the entire revisional application is based on 3 principles of law and on admitted facts. My lord, admitted fact number 1, this is an application or a decree or a certificate under the RDB Act of 1993. Unlike or in contradistinction to surfacing, it is not surfacing. So, my lord, 93 Act is the application of general law, but only specialized for banks. What is the general law? The general law is Section 60 of the Transfer of Property Act relating to mortgage still holds the field. Now, if that holds the field, it is now well settled that the right of redemption, which, my lord, a mortgager has, is, my lord, preserved till the very end. My lord, till such time, my lord, in a sale, a decree is not registered. It is, my lord, well settled now. There are more than one Supreme Court on this, more than 2 Supreme Courts on this. Because lordship recalls, prior to the 93, my lord, the tribunals coming in, my lord, in a civil court, my lord, order 34 suits. My lord, we are accustomed to preliminary decree and final decree in a partition suit. But, my lord, banks who order 34 mortgage suit, you get a preliminary decree and you get a final decree in terms of either redemption or foreclosure, whatever you want. All these are argued at the final decree stage. This is so far as the law is concerned. Now, once, my lord, in my respectful submission, there cannot be a dispute that it is the 93 Act and Section 60 of Transfer of Property Act applies. My lord, 3 dates are relevant. One is, when is the date of the certificate? As on the date when the balance amount was placed, what was the decretal amount or the certificate amount calculated as per the decree? And the third test is whether, my lord, if the security which is already put in court and the amount which was there, if it is there, my lord, my right of redemption is there. The unfortunate part is, because now the bank tribunals are dealing so much with the surfacey matters, where there is a specific provision, because, my lord, surfacey takes place, my lord, now it is well settled that you don't need a decree, it is akin to an execution prior to the decree. So you have specialized rules where they say that to attract purchasers and all that, special provisions have been made, special rules are there. But so far as, my lord, this is not involving surfacey, and both me and my learned friend should be ad idem on that. So surfacey principle can't apply. Unfortunately, my lord, the same tribunals are hearing so much of surfacey matters, they get bogged down by those principles and they go into other issues which have no application whatsoever. Now, in this context, kindly see the list of dates. That 15th November 2006 is the credit facility, 1 crore 48 lakhs and odd.
This is my land.
And, Miller, this is given in respect of the mortgage property of 237 kathas, which, Miller, is comprising of 4 deeds. Then, Miller, 5th October 2013, the account of my client was declared as a NPA. Well, this is not material because, again, NPA, my lord, it may have relevance in surfacey, but we are now on a certificate and it is in execution proceedings. So equivalent of civil court would be order 21 proceedings. 25th March 2019, final judgment and order in OA so and so by learned presiding officer issuing certificate for a sum of 1,60,91,000 and odd with penalty light interest at 10.25% per annum from date of filing of OA till full and final realization. So principal amount quantified, interest amount there from the date of filing, and 2nd March 2022 execution proceedings before RO, where it is directed to take physical possession in respect of mortgage property, appointing a receiver. Then, my lord, 3rd September, 4 valuation reports filed by bank in respect of the mortgage property, having a total reserve price of 3.69. My lord, here there are valuation issues. I am not pressing for that. I am not troubling your lordship for the time being, because, my lord, I am on a more fundamental point, but so occasion arises, we'll also argue that, because, my lord, half of the land, my lord, it's Karkhana and half is different. They have classified the entirety as Bastu and violation, and, my lord, reduce the value. That is all right. That is all right. But I am on, my lord, today, my lord, my right of redemption, because if I am successful on the status quo, my lord, as an interim measure, my lord, if I can show your lordship that I have put in that amount and I have exercised my right of redemption correctly, lordship will grant a status quo. Then, my lord, 13 November, order passed by RO fixing the terms in which auction of the mortgage property will take place and sale notice. 24th December 2024, an order of status quo was passed in MP case filed by the appellant in Barashat Court. Then, my lord, 8 January, order passed by the Debt Recovery Tribunal dismissing the interim application, thereby fixing a date for re-auction. Then bid amount deposited by the auction bidder for a sum of 36,94,000. Order passed by RO directing sale of scheduled mortgage property. 8 January, 10 January, yes. Now, my lord, this 8th and 10th January order is challenged before the presiding officer. Orders of the recovery officer is challenged before that. 13 January, balance amount of 25% in respect of all 4 mortgage property amounting to 56 lakhs has been paid by the auction holder bidder with EMD of 36,94,700. So, my lord, this is a very crucial date. 24th January, appeal under section 30 was preferred by the petitioner, depositing a sum of 1,85,070, being 50% of the alleged dues claimed by the bank before DRT. 1,50,000 I have paid. 1,85,000, kindly marks it, 24th January 2025. 27 January 2020, remaining 75% amount of all properties paid by the highest bidder, totaling sum of 2,79 and odd. Case was posted on 10th February for confirmation of sale. Kindly notes this, confirmation of sale is on 10th of February. 6th of February 2025, order passed by DRT 3 in appeal so and so refusing to provide interim protection. Then, my lord, 18th of February, petitioners paid a sum of 1,41 lakhs to bank through RTGS so and so appeal filed as a condition.
Then what was due?
Now, if lordships adds up, 1,41,55,231 with that of, my lord, 1,85,70,583.
That comes to 3.27. Yes, yes.
Yes,
DRT.
deposited in DRT.
Because that's tender.
Well, that is,
the tender.
well, it is, my lord, tendered, it is tendered in DRT, it is to the credit of the proceedings.
But it will be realized by the bank.
No, but yes, so no. Today, it is for the purpose of, it is statutory mandate. It is, if I fail, it will go to the bank. I will not get it back. I will not get it back.
They will get back their money.
No, that's, that is on a technical point. But, No, no, my lord, my lord, the DRT will pass orders. I am showing my bona fide, my lord.
আমার অ্যালাউ আপিলটা অ্যালাউ করে দিলে
My lord, if my appeal is allowed,
the money will go to bank.
no, no, if my appeal is allowed, money will go to bank. No, no, my lord, let us visualize it in this way. My lord, just bear with me for 1 minute. I think, my lord, I am only joining issue in one aspect. My lord, lordship is making a distinction on a technical plea that, my lord, the money lying in DRT is not money in the hands of bank. This is what is troubling your lordship. My lord, kindly visualize, my lord, in any money decree, when we prefer an appeal and we secure it in court, my lord, that amount is treated to test the bona fide of the appellant.
রেজিস্ট্রারকে আমরা সিকিউর
And my lord, we often lordships direct, we secure it before the registrar and all that. And it is treated to be payment because, my lord, over here, it is treated to be payment made by the appellant. So today, my lord, when testing redemption, if lordship holds that, because, my lord, what is the purpose of putting in the money? To show my bona fide, correct? So if I have shown my bona fide and let us treat both the amounts as security. Well, today, if I would have come before your lordship and I would have said, here I am depositing the entire decretal amount with interest. As of now, the sale deed has not been executed. I am depositing it here. It's not going to the bank. Lordship kindly hears it and stays it. Then also, my lord, it would be the same. They would not get direct. My lord, it would not have conferred any right. But, my lord, my lord, question is whether I have exercised my right of redemption or not. Lord, I have to show only three things. Number one, I have exercised my right.
What is the
Number two, my lord, what is the decretal sum, and as on that date with interest, what is the amount? Number three, whether the entire amount is in the hands of the court or the adjudicatory authority, so as to, at any given point of time, my lord, give it to the bank. If these three tests are satisfied, my lord, in my respectful submission, how can my right be prejudiced?
60 language হচ্ছে পেমেন্ট অর টেন্ডার
And, my lord, kindly see the section of section 60, my lord. Unfortunately, my lord, too much of surfacey has spoiled the. Kindly see section 60. একটা ট্রান্সফার দেখি আমাকে ল্যাপটপটা
আমি আইপ্যাড থেকে দিচ্ছি আপনি এটা দিন জজ
well, kindly have a look at section 60.
এই যে
আমার ইয়েটা কোথায় আইপ্যাড
স্যার এই যে সেকশন 60 করুন
let us read section 60 once, my lord. Right of the mortgagor to redeem
টেন্ডার
at any time after the principal money has become due, the mortgagor has a right, kindly note, on payment or tender. So, my lord, tender is also taken care of. It is not necessarily restricted to payment, and it's on payment or tender at a proper time and place of the mortgage money, to require the mortgagee to deliver to the mortgagor the mortgage deed and all documents relating to the mortgage property which are in the possession or power of the mortgagee. Where the mortgagee is in possession of the mortgage property, to deliver so and so, so and so. Now, my lord, kindly note at what stage I can do. My lord, just one paragraph of a Supreme Court judgment.
ম্যাথিউ বর্গিস ওখানে 77 কোট করা আছে
My lord, I rely only on the lordship is aware of it, the Matthew Varghese judgment. প্যারাটা বল কি রে একটা কপি এনেছিস? Lordship just gives me a
এই
moment.
যে আমার কাছে মার্ক করা আছে প্যারা 36
My lord, Matthew Varghese, my lord, quotes the other part. My lord, kindly come to paragraph 36. Having analyzed the relevant, because my lord, in Matthew Varghese, my lord, they relied on the surfacey rules. Having analyzed the relevant statutory prescriptions under surfacey as well as 2002 rules to refer the decision placed before us, before examining the manner in which sale of the secured asset of the first and second respondent was dealt with by the fourth respondent bank, and by effecting sale in favor of the appellant hearing. Mr. Diwan Lanet's senior counsel relied upon the decision in Narandas Karsondas. Narandas Karsondas is the parent judgment in which the right of a mortgager as prescribed under section 60 of TP Act has been spelled out. Will it kindly straight away come to para 35, which has been quoted over there, 34 and 35. This is the quotation of Narandas, so I don't have to cite it separately. I am reading para 34 of Narandas. The right of redemption, which is embodied in section 60 of the Transfer of Property Act, is available to the mortgager unless it has been extinguished by the act of parties. The combined effect of section 54 of the Transfer of Property Act and section 17 of the Registration Act is that a contract for sale in respect of immovable property of the value of more than 100 rupees without registration cannot extinguish the equity of redemption. In India, it is only on execution of conveyance and registration of transfer of the mortgager's interest by registered instrument that the mortgager's right of redemption will be extinguished. The conferment of a power of sale without intervention of the court in a mortgage deed by itself will not deprive the mortgager of his right to redemption. The extinction of such of the right of redemption has to be subsequent to the deed conferring such power. The right of redemption is not extinguished at the expiry of the period. The equity of redemption is not extinguished by mere contract for sale.
Is a mere contract for sale.
Now, my lord, sale certificate issued by DRT, my lord, is a mere contract for sale. Because, my lord, after that, there are two stages, deposit, then, my lord, a conveyance has to be executed in favor of that. No, I am not on surfacing, my lord. My lord, so far as DRT certificate, my lord, it is akin to a civil court decree. It requires registration. Surfacing, my lord, special rules promulgated, and that is why the distinction. And then para 38, my lord, I'm sorry I'm detaining your lordship, but since I am on this point, just have a look at para 38 before lordship rises. On a reading of the above paragraphs, we are able to discern the ratio to the effect mere conferment of power to sale without intervention of court in a mortgage deed by itself will not deprive the mortgager of his right to redemption. Execution of the right of redemption has to be subsequent to the deed confirming such power. The right of redemption is not extinguished at the expiry of the period. Equity of redemption is not extinguished by mere contract for sale, or the mortgager's right to redeem will survive until there has been completion of sale by mortgagee by a registered. Now, lordship will test it when I had put in that amount, whether there was completion of sale or not. If I have tendered the amount and more than what was due, if I have tendered it before completion of sale, well, it's an equitable right which I have exercised. And on that basis, still lordship hears it, my lord, I am entitled to the interim order of status quo. Because, my lord, the money has been tendered. Money has been tendered. It's either in DRT and over here. So, my lord, it is there. Yes.
Before
Yes, my lord, we shall be here.
I, my lord, may I humbly submit for the option, my lord. Here, my lord, learned senior friends. Oh, after two.
Before rising, my lord, very next matter is my lord, there is a matter fixed at court number 11.
দেখতে চাইলে দেখি না একটু বলা
নাম
Yes, your lordship has kept. That
I'm opposing.
whatever you want to do. I'm asking whether Mr. Sharma will permit me to submit or he wants to continue. Huh? Allegation তোমরা যা বুঝিয়েছো তাই হয়েছে। Lord,
এখানে মার্কিং আছে 941
মানে
এর মধ্যে মার্কিং আছে তো তোমার কি ওই 941 আছে মার্কিং
তোমার দুটো কিন্তু লাইন আছে না?
তিনটে আছে না
তো আমি কোনটা আছি?
তোমার এই 941 মেডিমিক্স আছে দেখো মেডিমিক্স
ও আমি তো জানি
কোন বিলটা দিয়েছো মেডিমিক্স হ্যাঁ তাহলে
যেটা দিয়েছো সেটাই আমার
কাইন্ডলি টেক 941 CO 941 মেডিমিক্স তো
মেডিমিক্স হ্যাঁ। Lord, our challenge, my lord, is to, my lord, order, my lord, which we say, my lord, is without jurisdiction, my lord, which is 10th March 2026. Lord, we made an application, my lord, before the NCLT, saying, my lord, the land belonged to us, on which, my lord, the machineries were all embedded. Now, that's the application. My lord, when the liquidator, my lord, was selling it, he obviously put, my lord, only the machineries, but my lord, in effect, what was happening was it was sale of land as well, because I won't, otherwise, my lord, I'll be denied access, my lord, to my land. So it could not have been sold, my lord, in that manner. My lord, there was an order which was passed on, my lord, 3rd July 2024. On my application, which, my lord, basically, my lord, said, recorded, my lord, our submission, saying that, my lord, according to us, that land for which the liquidator has issued the auction sale notice belongs to the applicant. Learned counsel appearing. I'll just want to show that, my lord, that's, my lord, it's an exposure. My lord, if, my lord, comes to, my lord, the my lord, if, my lord, comes to the impugned order, my lord, it's also set out. My lord, that's the application. If, my lord, comes to, my lord, page 8. Lord, page 8. আমার তো সব উল্টো পাল্টা ব্রিফ আছে। Lord, page 81 ফার্স্টেও তো থাকতে যাচ্ছে।
এখানে ফার্স্টে
impugned order. Lord, kindly comes to, my lord, page 81, which is passed, my lord, on a contempt petition. The contempt petition numbered 4 of 2026, seeking initiation of contempt proceeding against Mr. Sansach, the liquidator of the corporator Amrit Hatcheries Private Limited, primarily aims at grant of the following reliefs. And, my lord, rule be issued calling upon the contemptor respondent as to why the contemptor respondent Sansach should not be punished for contempt. Then, my lord, 3.2, 3.3. Then kindly come to page 87, paragraph 5.4. We have stated on, my lord, what are the acts of contempt that has been recorded, my lord, in the court's order. And then, my lord, page 87, 5.1. On 3rd July 2024, being taken good note of the submission of the applicants and other applicants in IA Sansach that their land have been included in an e-auction sale notice issued by the liquidator. This tribunal had restrained the liquidator from finalizing auction in regard to the said lands. The said order reads as under. My lord, when it says that their lands have been included in an e-auction, quite naturally, my lord, the submission was that not the land, but obviously if the machineries are embedded, that means you are also parting with the land which I own. So on that basis, my lord, this is what was recorded. That's what, my lord, the court's perception was. I'll show, my lord, the application. Learned senior counsel parties present submits that this is, my lord, the quoting, my lord, from the 3rd July 2024 order.
Learned senior counsel submits the land for which the liquidator has issued the e-auction sale notice belongs to the applicant. Learned counsel appearing for the liquidator submits that the said land is not included in the auction. In this regard, learned counsel seeks to file an affidavit within a period of 1 week. Regarding lot number 2, there is no restraint for e-auction as both sides confirm that the land in this lot does not belong to the applicant. Let the auction be held on the scheduled date. But the same, then kindly see, my lord, but the same shall not be finalized till the matter is heard out. So, my lord, this 3rd July 2024 order is subsisting, and my lord, the application is also pending, which has to be heard out. Whether, my lord, the liquidator could have sold. Liquidator, my lord, could have sold, my lord, the plant and machinery is embedded in that land, which land, my lord, belongs to me. Then, my lord, 5.2. Thus, it was owing to the dispute raised by the said applicants which had caused this tribunal to restrain liquidator from going ahead and finding the e-auction sale. It should be finalizing the e-auction sale proposed to be held on a scheduled date till the matter is heard out. That's one of the court's prerogative, done it. The said order dated 3rd July 2024 is said to be regarded in the lot 1 of the assets, and having found that there was no land that belonged to the applicant in lot number 2, no restraint order was passed in regard to this lot. This tribunal, however, also noted the contention of liquidator through the learned counsel, such that the auction notice does not include land for which he was even ready to file an affidavit within 1 week. The present applicant accuses the liquidator during the course of the hearing that not only liquidator permit e-auction sale to be held and concluded, but also finalized the same without seeking leave of this tribunal and without waiting for the outcome of the pending application, which is in blatant disregard of the order dated 3rd July. This tribunal thus entrusted with the duty to find out whether its order dated 3rd July 2024 has been deliberately violated by the liquidator. This is really, my lord, in a contempt that one has to look into. Then, my lord, submission of the applicant. Applicant contends that third-party land owning entities who have preferred separate 4 application numbered such and such. 4 separate applications to protect its right, title, and interest arising out of various portions of land aggregating approximately 26 decimals. Then, Mulad skips over. The subject land belongs to the applicants, which the liquidator proposes to pass off as asset of the CD to the auction purchaser and are situated near the factory unit of the corporator, namely Amrit hatcheries, and need to be urgently protected. Then, allegations of the applicants that of the following nature. Then, Mulad, inherent coherence and such. This is the grounds on which we say, and then kindly take paragraph 7 10 থেকে দেখায় 9 paragraph 9 আর আগে কিছু দেখা যাচ্ছে So, my lord, only steps, my lord, have been quoted. I'll show that. Then 9, we have noted the tenor of the order that it passed on 3rd July and that it passed in the context of rather being influenced by the submission made by the applicants, that the lands have been included in the auction notice and could be put up and would be put up for sale. The e-auction sale notice dated 4th June in regard to lot 1 does not mention any land belonging to any of the parties whatsoever to be put up for e-auction. Description of assets are evident, therefore, as evident therefrom is clear and categorical. Then payment of full amount of sale shall stand completed. Liquidation execute certificate sale H1 bidder. Then 10.1.1. Thus, it leaves no room for any ambiguity or ambivalence in regard to the proposed action, which was towards the sale of building and structure, plant and machinery, and vehicles, as well as 8 trucks belonging to the city and not of any land. Now, buildings and structures, plant and machinery, with great respect, it is in relation, it's on the land. It's on my land. And that was the understanding when the 3rd July order was passed.
Separate entity.
The applicants, then 10.1.3, the applicants have by unscrupulous ways been successful to stall the entire liquidation process, preventing the liquidator from finalizing sale process by issuance of sale certificate in favor of the successful bidder. Then at page 1019 of this IA, The fourth bullet point clearly specifies sale of property and as a cooperator will be conducted in terms of the orders passed by the tribunal and sections and regulation guided under IBC. We thus failed to receive any violation of the order 3rd July. Then 10.3, 10.4. Now, the interpretation is made of the sale notice. And then kindly see 10.8. Para 9 further indicates that the finalization of e-auction process shall be based on the outcome of the order to be passed by this tribunal. In such IA number 127, IA number, here also we find no intentional, deliberate or contumacious violation of our order dated 3rd July 2024. In the aforesaid background, the applicant numbered Sunsat dismissed, contempt dropped, notice of any issue are discharged. Then 12, there should not be any impediment on the part of the liquidator to conclude the sale process with execution of sale certificate in favor of successful auction purchaser. And such the alleged non-compliance and Sunsat are identical to Sunsat are disadvantages. Now, three things will not happen here. First, the 3rd July 2024 order, in spite of that being present and the tribunal not having been able to dispose it off, in my contempt application, that order is again interpreted and Malad is taken out. There's no appeal from that order. No one has filed any appeal from that order. Liquidator has understood what the order is. And I'll show the application. The application is on the basis, and that's our grievance, saying that if you're selling the plant and machinery which are embedded there in the buildings, then that means land is also going away. So while passing the order, the NCLT understands my submission and says my allegation is that obviously land is going in that sense because the plant and machinery. You could have dismissed my application, said that no, sorry, or could have vacated the order. But in a contempt petition, and this is where the absolute transgression of jurisdiction happens. The order is also, we have given the order in the supplementary affidavit, the main order. Page 5 of the, that's the order, full order. It's been quoted, that's why I read from there. Can have a look at the order. So there can't be a change of stand subsequently in a contempt petition by the tribunal. If the order was incorrectly obtained by suppression, hear out the application. Hear out the application, not ignore that order. And I also understand, my contempt is on the basis that no, it doesn't, we don't think it's deliberate violation, you dismiss it. But you give further direction to say, para 12, there should not be any impediment. First of all, read 10 point, where it says 10.11 and 10.12. No, 10 point. 10.1.1 says, thus it leaves no room for any ambiguity, ambivalence regard to the proposed action, which was towards sale of building and structure, plant and machines. Then said, therefore, the misleading statement made on 3rd July 2024, 10.1.2, made on 3rd July on behalf of the present applicants of inclusion of land had prompted this tribunal to restrain the liquidator from finalizing the auction sale. Applicants ought not to have misled their respective counsel. Then the applicants have by unscrupulous ways have successful to stall the entire liquidation process, preventing the liquidator from finalizing sale proceeds by issuing a sentence in favor of the successful bidder. Well, all this with great respect, this is completely uncalled for. In a contempt petition, the tribunals, any contempt court, with great respect, it is, my lord, to look at the order to see whether there is contempt or not. If there is no contempt, you dismiss it. But not to say that earlier order which is pending, my lord, subsisting from 3rd July 2024 with no objection, my lord, from either side. And then to say I'm confirming, now there's no impediment. In the contempt, I've said that it was obtained by unscrupulous means, therefore now the liquidator should. And now, my lord, kindly look at, my lord, the application on which this order was passed. My lord, it's at page 59.
This is my.
And it is, my lord, with great respect, my lord, the tribunal, if the tribunal misunderstands, my lord, what is the effect, because that time it must have understood. Kindly, my lord, look at, my lord, page 59, my lord, is the IA on which, my lord, 59, my lord, of the main, my lord, has that. Then, my lord, kindly have a look at, my lord, paragraph 2. Paragraph 2. The applicant is the owner of diverse portions of land aggregating to approximately 175 decimals, which is equivalent to 1.74 acres at Southern Search, Bardhaman, hereinafter referred to as the subject land. Particulars of land owned and possessed by the applicant will appear from the deed of sale, which is annexed to and marked with the letter B. Then respondent and liquidator appointed by this honorable court pursuant to such. Then, my lord, kindly come to straightaway paragraph 5 at page 62. The applicant states that the applicant is the owner of the land in respect of the dag numbers which have been more fully set out here and above. Out of the total land belonging to the applicant, the land comprised in dag number 388 are completely situated and are located in the vicinity and adjacent to other parts and parcels of the land, which includes the land belonging to the corporate debtor. Plant, machinery and buildings with regard to the corporate debtor will be found situated and or embedded upon the land. So this is my case. Embedded upon the land comprised in dag number 389, which is situated within the boundary wall of the land, whereby the factory, plant and machineries and buildings of the corporate debtor are situated along with the parcels of land belonging to the other entities apart from the applicant. However, a major portion of the land comprised in dag number 388, which also belongs to the applicant, is partly situated outside the boundary wall of the land, wherein the factory, plant and machinery and buildings of the corporate debtor are embedded and erected for the kind convenience and arbitrary sketch plan of the Moja maps and such is annexed. And then, my lord, kindly also look at paragraph 9 at page 64. The applicant is the lawful and legal owner of the land, which would appear from the title documents disclosed in respect to dag numbers 388 and 389. However, in much as the chicken processing unit of the corporate wherein the factory building, plant and machinery and other assets have been erected, inter alia also upon the land belonging to the applicant, the respondent liquidator while selling the assets. Then can you see the respondent liquidator while selling the assets and properties of the corporator had ventured into an illegally and wrongfully allowed other third parties to encroach upon the land belonging to the applicant, whereby whereunder today the applicant is denied and obstructed, prevented the entry into its own land, even though the applicant is the valid owner having the right, title and interest over the subject land as described above. It is an admitted position that the corporator was never owner of the land comprised in dag number 388 and 389, as more fully described deed of conveyance, which annexed is annexed B here and above. However, the liquidant kindly similar. However, the liquidator respondent in course of conducting the liquidation sale of the corporator misused his powers and duties and proceeds to take steps to issue e-auction sale notice dated June 4, 2024, inviting bidders to participate in the sale of assets of the corporator, which includes the building, plant and machinery, which are located within boundary walls as indicated in greening in the Mojo map, which compromise various parcels of land which belongs inter alia to the applicant and other entities apart from the corporator. Nobody's case that the entire chicken processing unit situated land is entirely belonging to the corporator. Whatever arrangement corporator had with other landowners wherein the chicken processing unit was set up does not empower the liquidator respondent to proceed to include the building, structures, plant machinery and other assets of the corporator to be sold to third party bidders by issuing the auction sale notice without first issuing the necessary clarification then part and portion of the land wherein the building structures, plant machinery and other assets of the corporator which houses the chicken processing unit of the corporator is situated on land which does not belong to the corporator. Therefore, to such extent, the auction sale notice June 24 is incorrect, misleading, does not depict the true and correct state of affairs. Copy of the auction notice and such. Then, my lord, kindly see, my lord, the last 5 lines of that paragraph. Same paragraph, my lord, paragraph 10 at page 65, my lord. Last 5 lines. What is our case? If the liquidator is allowed, just before paragraph 11, my lord, if the liquidator is allowed to proceed to sell the assets mentioned in the auction, sale notice dated June 4, 2024, under lot 1, the same will compromise the interest of the applicant and other entities who have unfettered rights as owner of their part and portion of the land, which is within the boundary wall marked in green ink, which houses the chicken processing unit of the corporator. So, my lord, what had happened, my lord, this, there's, my lord, a chicken processing unit, my lord, of Amrit hatcheries. Now, this chicken processing unit was built over, my lord, some lands belonging, my lord, to the corporator itself and some land belonging to, my lord, other entities, my lord, which may or may not be owned, my lord, by the promoters themselves, but, my lord, there are other corporate entities. So, question today is, my lord, whether in the sale of assets of the corporate debtor, the land held by other entities who may be related to the corporator, doesn't matter. Land held by other entities who are not part of the corporate insolvency resolution process could be sold or not. Now, this is the subject matter of the application which resulted in 3rd July 2024. So, whether the liquidator is saying, that he is only selling the buildings and the plant and machinery, because that's one issue. Whether the liquidator is saying he is only selling plant, building and machineries. Now the question is whether it can be sold without the land also being transferred. He is saying the land, I am not transferring the land, but that's not the point. The point is, along with building, plant and machineries, this land is also going in the possession of a purchaser. Now, this is the subject matter of 3rd July. Maybe what I'm saying is wrong. Maybe the court will come to a solution as to what is to be done. Either I might get compensation, I might agree to also transfer my land. Correct. According to me, it has gone beyond the jurisdiction of a contempt proceeding. To say, oh, you misled me into passing that order without really looking into that application to see what is the subject matter. We have not said that, we have clearly said that the building, plant and machineries which are being sold will also, which it does, encompass the land. And the liquidator should have given a clarification saying that, look, please understand that the building, plant and machineries, they stand on land which doesn't belong to the corporate debtor. That clarification was not given. Now, my lord, with great respect, my lord, what is the order of 3rd July 2024? It says that, my lord, let the auction, last paragraph of that order,
No, it is
pending.
7th May.
Fixed on?
7th
May. Fixed on 7th May, I'm told. Yes, but with respect, the interim order is gone. By reason of the contempt, the interim order is gone. And then you have recorded in unscrupulous manner. What remains of that application? Today, in the contempt, with great respect, that is why, we have come up, in revision, that you have exceeded the contempt court, you have exceeded your jurisdiction to make all this observation and also vacate the interim order. Because paragraph 12, now says, go and issue the sale certificate. The order was, if my lord looks at page 6, my lord, of the supplementary affidavit, it says, let the auction be held on the scheduled date, but the same shall not be finalized. But the same shall not be finalized till the matter is heard out. And this order subsisting. And now, my lord, what they have done, my lord, without, my lord, this order, my lord, being vacated without that application meaningless. They don't pass interim orders. If you pass an interim order, the court itself passed an interim order subsisting. You do not hear the application. In a contempt petition filed by me, you vacate that interim order. You hold that, sorry, I'm vacating, because obtained by unscrupulous means. Misleading. Where is that jurisdiction? And now, my lord, we'll find. My lord, what they do, my lord, why we came up. Now, auction notice. 464. If, my lord, I'm sorry, my lord, may I just show one more document? Now, order 226, page 226. My lord, in page 226, my lord, of my lord's volume 2, my lord. No.
This is the e-auction process document. This is the LOI and purchase considerable accepted.
What about the 293? My lord, kindly see, my lord, this is, my lord, one of the
E-auction process document.
226, my lord. The auction process, my lord. Note 1, my lord, will see. Currently, there are 4 applications filed for custody of the land parcels situated in the vicinity and adjacent to the factory premises of the corporator when the Honorable Company Law Tribunal, Kolkata bench. The applicants are listed for further consideration on 22nd March 2025. Details of which are hereunder. Now, D is what I'm arguing. This may, C. Same order was passed, in all 4 matters. This is the present one which is considering. Then says e-auction for both the lots shall be finalized as per outcome of the aforesaid application by the Honorable National Company Law Tribunal. That is not the order.
Not to finalize.
Order says, my lord, but the same shall not be finalized till the matter is heard out.
LOI issue.
And here, my lord, it says the e-auction for both the lots shall be finalized as per the outcome of the aforementioned application by the Honorable.
LOI.
So this is, my lord, why we came up. To say, sorry, you can't do this. This is in contempt of the court's order. And in that context, my lord, the order is passed, my lord, the impugned order, my lord, of 10th March. Now, my lord, kindly see what they have done. My lord, what remains, my lord, of the interim order?
Page 239.
My lord, page 239.
These things successfully e-auction.
কত বলো?
239.
239.
E-auction.
Well, this is the liquidator. Volume 2, page 239. It's a subject, sees subject declaration of the successful bidder and issuance of letter of intent.
HON'BLE feeds the bidder successful.
This is the successful bidder.
HON'BLE feeds.
So what remains? Subject declaration of the successful bidder and issuance of letter of intent. This is reference to the auction process and such. This is provided. Then, kindly see paragraph 2. Terms of the procedure of good office. Shortlist bidder was identified. Successful bidder for block 1. The bid of rupees such. Being 100% of reserve price were identified as the highest bidder for block 1 of the said auction. Details of the assets are provided in the success schedule hereunder. Then 4 says, as civilian procedure document, you have been selected successful bidder subject to following conditions. provided liquid, remit the 25% of bid price, which shall exclude the earnest money deposit on or before 14 March. Then balance consideration, everything will not accepted. And then let's see on payment, page 240C, on payment of the full amount, the sale shall stand completed. The liquidator shall execute certificate of sale in favor of the successful bidder. You as the successful bidder must undertake accept the LOIs, answer. And Muller at 262, Muller just wants to see Muller that sale consideration is also used for Muller meeting the liquidation expenses. So it's an irreversible Muller what they're doing. 262 Muller. Muller, this is Muller part of Muller the stakeholders committee minutes meeting. Muller, that starts at page 2. Sorry, Muller, it starts. Muller, 247, Muller, it starts, but Muller will. It's dated Muller 7th April 2025 at 262. Second last paragraph, Muller will find 262, second last paragraph. Chairman Muller is the liquidator. To 262 second last, the chairman has video email dated 2nd April 2025 sought concurrence of the member of the stakeholders committee, consultation committee being PNB to allow utilization of the earnest money deposit and 25% of bid price totaling to rupees 79 lakhs to meet liquidation expenses and invoices received for the period of 1st January till 31st March 2025. Yes, so correct. Yes, yes. My lord, absolutely correct. My lord, whether NCLT has exceeded in jurisdiction by, my lord, commenting on the order of 3rd July 2024 by practically making it, my lord, practically beginning it without, my lord, hearing the application. Because that means, my lord, the sanctity of any order, my lord, does not survive. If you file, I file a contempt, my lord, and my order goes. And then paragraph 12, my lord, saying now you liquidator go ahead and issue. So kindly see, my lord, as a proposition of law, what is being established before the National Company Law Tribunal, my lord, is that in a contempt petition, the court will then be permitted to question the sanctity and veracity of the previous order passed, and also will disregard that order and give Muller further direction with regard to liquidation sale. I don't mind. You please decide on that 3rd July. And I might have a very bad case, I might have a good case. But not by way of this, Muller, side wind. Muller, Muller knows, Muller, the law, but we just wanted to rely, Muller, on this division bench. Muller, this is 2018 SCC Online Calcutta 16094. ওই অর্ডারটা দেখালে না 15th October 2025 এর 413 তে একটা অর্ডার ছিল এটা কোন অ্যাপ্লিকেশনে ফাইল করেন 413 and 40 Muller, in this, Muller, kindly just have a look. হ্যাঁ আছে এটা কোথায় হ্যাঁ আমার কাছে বার করছি Muller, this is an application এটা দেখাচ্ছি আজকে দেখি yes impugned dealt with the contemplation. Yes, paragraph 8. Furthermore, if the impugned order is to be read as an order passed in a contempt jurisdiction, we are of the view learned trial judge erred in law in modifying a mandatory order passed in the writ jurisdiction subsequently to contempt jurisdiction. In the contempt jurisdiction, either the power of the writ court is to hold the contempt or reject contemplation. Power of modification order passed in contempt which is sought is not available to the trial judge. Then, my lord, 9, aforesaid proposition of law can be further fructified from the decision of the apex court rendered in case of Union of India versus Subedar Davasi. Then, my lord, it's quoted. Lord, the quotation, my lord, has also had a look, my lord, in the middle. Yes. And then, my lord, paragraph 10. In view of the above, it is clear that the examination of the correctness of the earlier decision that has been done in the present case is bad in law. In view of the same, we set aside the order dated 11 July 2018 and direct both contempt number, direct both the CC number 7 of 2017 and G number 1 to be restored to its original file and number. Learned trial court request to dispose both the applications as expeditiously as possible. Now, my lord, just one more, my lord, order which I wanted to show. I got it. My lord, if page 413 of my lord's brief, you know, volume 3. Sorry, yes, my lord. Application order. My lord, in that application, my lord, when my lord in one of the hearings, kindly see, my lord, 15th. No, my lord, yes, my lord. Page 413. Learned counsel appear behalf liquidator submits he would come up with appropriate application. The kindly see, my lord, learned counsel appearing on behalf of the liquidator submits that he would come up with appropriate application to seek leave to issue the said certificates regarding Panagar property since the same is not available before us. We keep it, that's been filed now, we keep it appropriate to adjourn the matter about the timing in view of the fact that the auction is conducted, successful auction price has already been paid the consideration amount. It is submitted that the successful auction purchase in regard to all the properties with the corporate debtors, whether situated in Ondal, Kashiberia, Sansach, access to the building plant and machinery that have already been purchased by them. Liquidator as well as landowner will also indicate what was the arrangement with the corporate debtor regarding the land in question. Now kindly see, over which the building, plant and machinery of the corporate debtor was allowed to be constructed. In regard to the Ondal property, access road. So, Mala, this is 13th October 2025. Sorry, 15th October 2025. So the bench is aware as to what is our case. In the progress of the same application. And then, when it comes to 10th March 2026, we find strangely, that now 10th March says that no, first order obtained by suppression, misrepresentation, we are confirming the sale. Please hear out my application. You can't modify. You hear out the application. That is what is in excess of jurisdiction. My respectful submission is 10th March should be set aside, and we should really go back and have my applications and the contempt heard out. If they think that our order does not survive, and it will not survive, and it will be then confirmed.
13 June order. This is liquidator's understanding of the order. So that a restraining order.
Well, I'm sorry, my junior wants to. Lord, I'm sorry, just one more order. Same volume 2, page 263.
First paragraph. That will liquidator's understanding of the order. That will be a restraining order. And that.
This is again, 13 June 2025. Mulad 213, sees again 13 June, before that 15th October. And this is during the progress of these applications. Learned counsel appearing on behalf of the liquidator submits that a restraining order passed by this tribunal, where we are directed that the auction do not finalize until pending applications are decided. So, my lord, 13 June also, my lord, I'm just showing, my lord, the progress of the matter. It is well understood. 213, my lord.
263.
Sorry, I'm so sorry, my lord, 263. Sorry, my lord, 263. I'm so sorry. First paragraph, my lord, of that order. Again, my lord, in the course of liquidation, learned counsel appearing on behalf of the liquidator submits that a restraining order passed by this tribunal where we are directed that the auction do not finalize until the pending application is decided. So, my lord, I am only on the question that, my lord, just because, my lord, I am also, my lord, part, my lord, if other corporate entities, my lord, own the land, it has to be decided, my lord, as to what happens when there's a sale of building, plant and machinery situated on the land. And that, my lord, whether that doesn't matter. Whether, my lord, I am related, my lord, part of the corporator's associate company, not associate company, that is, my lord, not. My lord, I am on the question, my lord, as to how the contempt application has been dealt with by the order of 10th March 2026. And, my lord, also confirming, my lord, paragraph 12 of, my lord, the order.
Go ahead and issue sale certificate.
That's, my lord, a modification, my lord, of the order. That's right. That's right. That's right. That is different. My lord, that would have been, my lord, my submission. Only, my lord, why I, my lord, respectfully, my lord, join, my lord, issue there is because, my lord, at 10.1.1, my lord, observation in paragraph 10.1.1, 10.1.2, 10.1.3, whether, my lord, that is the cause why, my lord, the contempt application got dismissed.
Come to find.
That is very important. This is what you can't do. You can't, in contempt,
Everybody understands.
absolutely. Absolutely. But, my lord, here, my lord, it is not only that. It is, my lord, saying it is not a question of interpretation of the order.
You also understand.
It's not a question of interpretation of the order. Order is understood, my lord, as it is. It says, therefore, the misleading statement made on 3rd July on behalf of the present applicants above inclusion of land had prompted this tribunal to restrain the liquidator from finalizing the auction sale. Oh, sorry, my lord.
10.1.2.
Sorry, my lord. Page 892.
10.1.2.
10.1.2. Therefore, the misleading statements made on 3rd July 2024 on behalf of the present applicants about inclusion of land had prompted this tribunal to restrain the liquidator from finalizing the auction sale.
Applicants not to have misled their respective.
The applicants ought not to have misled their respective counsel. I've shown, my lord, the application and also shown their understanding. Then 10.1.3. Applicants have by unscrupulous ways been successful to stall the entire liquidation process, preventing the liquidator from finalizing sale process by issuance of sale certificates in favor of the successful bidder. And then, my lord, that is followed, my lord, with paragraph 12, where, my lord, the court says there should not be any impediment on the part of the liquidator to conclude the sale process with execution of sale certificates in favor of a successful auction. This is, my lord, what we are agreed by, my lord, whether, my lord, this is something, my lord, which is within, my lord, the contempt jurisdiction or not.
Contradiction.
I'll try to.
অন্য গ্রুপ আছে
কি
245 অন্য বেঞ্চ
ও আচ্ছা
yes may know them
Tomorrow, your lordship may come to that tomorrow. Because today your lordships have heard this, so it would be.
শুধু করুন না, তাছাড়া 13th problem. 16th. Yes, that will not be no, my lord.
Tomorrow, your lord, I'll take.
16th আছে। 16th, my lord, if it's possible. 16th আছে?
Just a minute. 16th, your lordship.
না, হচ্ছে না।
No. 20?
30 तारीख रखो, 30 तारीख।
ओ
30th আছে।
30th আছে।
30 तारीख।
30th।
Just a minute.
So now the matter is on 7th May.
Yes, sir.
Basically.
Very well. Your lordship on 30th. Your lordship will kindly fix the time, your lordship. Because your lordship, today also the adjournment has been.
No, today because of paucity of time.
Today also the adjournment has been taken.
No, not the matter.
Mr. Sharma, I think I have not even completed. Why will you interrupt me?
No,
the
you
matter
have to
has
tell what
kept on.
happened.
What correctly? Have I said anything incorrectly?
No, I have not taken
Just
adjournment.
today the matter has been adjourned and has been kept it on 7th of May.
Matter has been adjourned because of paucity of time. No, I have not taken adjournment. Neither Mrs.
ठीक है,
Bogeli
जैसे
has
this is
taken
going on.
Why are you making unnecessary submissions?
5th, very good. 5th at 2 p.m. ঠিক আছে তোমার?
Your lordship, kindly keep it on 4th of May.
4th আমি নেই।
Very well. On 5th of
5th,
May,
2 p.m.
2 p.m. Very
Grateful. আমি ওখানে থাকবো না, বলছি তো আমি এখানে থেকে
Provision before the recovery officer for cancellation of sale. The section 60 they have not. Yes. Yes. Lordship. Yes. Any day or next week?
next week.
matter before the learned, long I have paid the entire sale constitution. It runs in crores. They
refund him
have no legal right,
entirety.
even the right which is sought to be canvassed. My lord will hear all the things. Insofar as the application which is stated to be taken up for hearing by the recovery officer, my lord, I'll seek an adjournment. I'll seek an adjournment, my lord. Before that, my lord will hear all of us insofar as the matter is.
The week starting 20th, Rakam, please. No, come on.
Another matter of which may take. I will try my best to complete it at minimum.
Resolution হয়েছে নাকি?
I'll come with notes.
16th
Resolution হতে পারে একটা তাড়াতাড়ি।
My lord, 13th, my lord, already some resolutions and all. Kindly keep it on 16th, my lord, or 20th.
20th is
The 16th.
16th.
16th. 16th, my lord. 16th is okay.
16 তারিখ আছে তো
16 তারিখ এনি টাইম। $10:30
2 PM বলছি
10:30 করে নি আমরা, বলুন না 10:30 করে নি।
2 PM করছো ফিক্স।
রেজুলেশন হয়ে গেছে দুটোর সময়। ডেটা রেজুলেশন মিটিং আছে তো আজকে।
Very well.
I'll make a prayer before the
record করতে বলুন একটু, কাইন্ডলি রেকর্ড।
At 2.
Lordship,
16 at 2.
Your lordship fix the matter. Your lordship, the next step has been fixed. Court will last 9 more.
কি করবে লোকটাকে ফল তো আটকে রেখে দিয়েছে।
হ্যাঁ
কি
ওরা কি হচ্ছে তো?
Yes, sir. Well, wife is the petitioner of this matter. The husband filed a suit for divorce. That suit was dismissed for default. Previous suit on 4 July 2014. That is page 25. Page 25. Page, yes, next page. 26. Then, my lord, yes, the date is dismissed for default. 4th July 2024. 14. Sorry, 14. Then, when my client, the opposite party, she appeared. The plaintiff petitioner was absent. That was dismissed for default. Then, husband filed another suit for dissolution of marriage after 7 years. Present suit. That suit, my lord, it is 2021. There is no application. That suit was not, no application for restitution of that suit. That was filed Fresh suit, present suit, yes. Now, earlier suit, other day, I handed over a copy of the plain. Others, no, you can't. 2010. You just got it, my lord? 2010? Suit for dissolution of marriage under section 30 of the Hindu Marriage Act. That on 29 July 2008, the parties got their marriage according to Hindu rights and same was subsequently registered such and such. They were state of your also can see. There's so many allegations against the wife respondent, my lord.
It is not annexed. Annexed.
That is not, that document is with you. That is your suit.
No, it is not
No,
annexed.
they are not annexed. I handed over a copy. Hand over a copy. But can you see in that suit, page 14, page 4. 4. Paragraph 17. The petitioner could not condone such immoral acts of respondent as such under compelling circumstances. The petitioner is filing suit decree for divorce. There is no chance of reunion, such and such. 19. The cause of action of the instant suit arose on defendants lastly on 19 July 2009. Then prayer. It is prayed that your honor will be graciously pleased to pass a decree dissolving the marriage between the parties and also cancel the registration of such and such. That is the suit. If I go to the entire facts, the facts, the present, earlier suit and present are same. Only, my lord,
copy the letter. Copy
then my present suit, page 10 in my petition. Present suit. But can you see? Paragraph 4, next page. That after the marriage, both the petitioner and respondent leave house of the petitioner, and the marriage was not consumed, but the petitioner observed the petitioner did not do the house work. The work was done. The petitioner's poor unmarried sister, such and such, but the respondent always demand costly cosmetic, garment, jewelry, and also demand money to give her parents her house with the petitioner told his inability. Then the respondent become. That's one. Other here, can you see, my lord? Cause of action, can you see? In this suit, page 15. In our page 15. Earlier suit cause of action was 2009. আমাকে দাও একটি earlier suit cause of action 19 July 2009. This suit, the cause of action suit arose on 29 July 2008. Previous to 2009. Thereafter, 10 January 2009. And prior, dissolution of marriage or the petition, the marriage, degree of divorce, any other reason. Then, on receipt of the summons, my client filed a written statement also, and then file an application or maintain that application. It is not that application I have annexed, my lord.
17.
27. It's not maintainable. The previous suit was pending before the suggest. Never can you see the ordering portion. But this is a present suit. It has not been not a single word that he filed a suit in the year 2010 that was dismissed for default. And why he has filed this application, there is no explanation. Other day, I cited two decisions. It's our High Court decision that limitation, there is no whisper, that has been suppressed in the present suit also, present application. That is what the division bench judgment. No, you have to, because order 9 rule 8, my lord. But that is 2018 volume 1 Calcutta Law Journal. 435. What to প্যারাগ্রাফটা বলেছিলাম, প্যারাগ্রাফটা কোথায় লেখা? Yes, my lord. প্যারাগ্রাফটা বলেছি। Yes, paragraph. Now, another judgment I cited before Lordship, another division judgment. But a recent judgment I handed over on last occasion also. That is 2026 INSC 292. That is Sarada Sanghi versus Asa Agrawal and others. Here also, when the defendant appeared, but plaintiff doesn't appear, that was dismissal. Provision order 9, rule 8, my lord. Can you see? Here also, paragraph 30 and 33. According to Black Dictionary, the maxims are no one ought to twice trouble. If it appears to the court that it is for one and the same cause of action, in simple terms, once a dispute relating to particular cause has been brought before a competent court, the same party cannot be allowed to use the very same issue. That is it. Yes. Yes. This one is that judgment is applicable. And the learned trial judge not had.
Yes, my lord.
The mentee report that has been dismissed, my lord, that application is allowed.
Yes, my lord. Kindly see the, my lord, impugned order 15/1/2025. My lord, here it is.
Yes.
Impugned order.
Impugned order.
It is clearly stated that the cause of action in the instant case has been continuing. It's not the same self cause of action. On earlier occasion, I handed over a paragraph of which judgment? I have not handed over. It was not handed over to me.
Yes, yes. Other day, yes.
No, it was not handed over to myself.
Other day, other day, 18 volume 1.
Yes. I am showing another judgment of Honorable Supreme Court. Here it is clearly stated that dismissal for default, not being dismissal on merits, cannot operate as res judicata.
That is it. Yes.
Two petitions, subject matter also are different. Only, well, I am saying.
Available.
2018
volume 1 Calcutta Law Journal 435.
This judgment is not in my right. Yes. My lord, question of suppression does not arise at all. No, my lord, only one thing, my lord. No, my only line is, my lord, not mentioning, my lord, only not mentioning is not always to tantamounting to suppression of facts. If, my lord, why it is not relevant, my lord?
Yes.
No. I am not saying. What I am saying, my lord. My lord, can you hear me for 2 minutes? Only 2 minutes. My lord, on earlier shoot, they appeared, and thereafter, my lord, a talk of compromise was going on, and on that very date, no steps was taken. They were present. So, suppression will not help us. My lord, it is well within their mind that a case was filed. So, why I will suppress? It is not an intentional act, first of all. It is always in your mind, in his mind, as because she also appeared in the said shoot, filed written statement. Thereafter, my lord, talk of compromise was going on. Now, my lord, only not mentioning is not the suppression of fact. There are several judgments to that effect. As because when it is suppressed, when it was not within his knowledge, that I can say that it is suppression of fact. It is well, not my knowledge now. It is well within his knowledge. The shoot is well within his knowledge. The shoot is well within his knowledge. And so, my lord, no, my lord, of course, it should be. But not mentioning is always not suppression of fact. That is, my lord. My lord, what profit it will make, my lord? As because it is well within his knowledge. Why I will suppress? And to adopting a different, my lord, then, my lord, what is the remedy of this old man, my lord? What is the remedy? He is filed this suit. They are separate since the last 14 years. They prayed for divorce. My lord, if lordship wishes, my lord, then I can amend the said petition. Kindly allow me to file an application before the learned trial court under order 6 rule 17. Otherwise, my lord, where he will go? My lord, otherwise, my lord, for the ends of justice, something should be done, my lord. If it is wrong, my lord, if it is illegal, then we cannot carry out through the whole life, my lord. I can file an application under order 6 rule 17 by incorporating the said facts. Then, my lord, should be proceeded, should be proceeded, my lord, in accordance with law. Where is the problem, my lord? And, my lord, in the said shoot, they filed written statement.
Yeah.
They filed written statement. After a long period, my lord, they filed this non-maintainability petition.
Like this judge and
And, my
paragraph
lord,
32 is very clear.
My lord, desertion is a continuing offense. Desertion is not same self cause of action. It is a continuing cause of action. Yes, my lord, I handed over. On earlier occasion, I handed over that judgment. Yes, Supreme Court judgment, my lord, I have handed over.
কোন জাজমেন্টটা আমাকে দাও
এর আগের দিন দিয়েছি সাহেব।
না না
একটাই
যে
ছিল।
জাজমেন্ট
আমি দিয়েছি এর আগের দিন দিয়েছি।
নামটা আমি খুঁজে বার করে যে উল্টো জানি
The clearly written page number 20, para number 21. My lord, kindly see, my lord, you record, my lord. এখন পাচ্ছি না।
পাচ্ছি না।
Yes, paragraph 20, desertion is a continuing offense, my lord. So give me some protection.
Of course.
If it is illegal in the eye of law, my lord, then I can file an amendment application for the ends of justice.
Yeah.
My lord, here it is. But, my lord, main theme is this, my lord, when the desertion, that is the continuing offense. And, my lord, in the said petition also, my lord. Yes. And, my lord, that is why, my lord, in paragraph number 13, in the said petition, present petition, my lord, I have categorically stated that the cause of action of the suit arose on and from 29/7/2008, thereafter on 10/1/2009, and thereafter every day, and it is still continuing.
The clever
So cause of action, clever judgment, that is why we have been engaged. That is why, my lord, day and it is still continuing of Nivedita Pulli, posters and PS Noyati such and such within the jurisdiction of Laurent Court. Yes.
Yes. But my was order 9 rule 8, but they have to file an application for additional that earlier suit.
Oh.
Earlier Earlier suit. Yes, yes. Only if I go to the, then earlier suit, I say go to the interest. Yes, my lord. Paragraph, my lord. 3. Since after marriage, respondent started torture mentally and with the reason, the respondent abused filthy language towards the petitioner unnecessarily. The actual marriage was settled by the husband. Since the day of the marriage, respondent started quarrel with the unmarried sisters. The asked them to leave the Satyans. Respondent also started to snatch the entire ancestral property of the bill in collision with the mother and other associates on refuse of the petitioner. The respondent refused to copy such and such. It is also to mention that the respondent used to leave matrimonial home without any consent and innocent to this petitioner or his inmate and used to stay at a father's house or elsewhere, which is not within the knowledge. That on protest the petitioner against such illegal immoral behavior activities of the respondent, she continually asked the petitioner to drop out the unmarried sister and to transfer the ancestral property of the petitioner in the name of petitioner. It is also to be mentioned that respondent left her matrimonial on taking a oral belongings such and such. Subsequently, the sister respondent informed the petitioner they are not getting the information about Soma and asked the petitioner to trace out Soma as a later such and such. The actually was a drama played by the respondent in collusion with her mother, and when the petitioner came to know about such activities, the respondent, your petitioner lodged a complaint to a local police station. Thereafter, the petitioner went to the information of the respondent or father's house when the mother respondent behaved most immorally and ill-treated with this and threatened him with dire consequences. Sent.
My lord,
Same,
but
I have
here,
read
my lord,
two
20 was
applications.
narrated, well, on that ground, divorce was not prayed, was not sought for. But here, my lord, desertion as well as
all the same.
My lord, my lord, I say, my lord.
That means he said that will be settled. 7 years.
Well, desertion is continuing.
It's a
Desertion
clever
is
drafting.
continuing.
No.
They did not.
And 7
I have
years.
written, I have
7 years you are silent.
No.
7 years after dismissal of the first suit.
My lord,
7 years.
my lord. I have written, my lord.
And no government filed is
that on 10/1/2000 paragraph number 7. That one.
And the railway employee, my lord. Railway employee.
That's now retired.
Now retired. I know it.
Go to her parental house without any information to the petitioner that her husband till from the day of respondent did not return to her matrimonial home. The petitioner tried to contact his wife, but the respondent was not available on her phone. Then the petitioner contacted his father-in-law, but he could not give any information about the respondent. The respondent told her that these are the new facts, my lord. These are the new facts.
And in paragraph 28, I have stated that this
Well,
that has been dismissed for default.
my lord. Both the parties are residing separately since the very inception of marriage. There is no chance of cohabitation or reconciliation. My lord, mediation, my lord, kindly, if they are ready, then my lord, I am ready to go. I am ready to go, my lord.
Not only that, but threatened in the Barakpur court, there is a yes. Yes.
Kindly direct my lord.
Not only that, he's threatened, he's sending the man also over phone.
Yes.
Unless I shall take instruction. Otherwise, I will lose it.
Yes, I am ready. I am saying I am ready. I already asked my client.
Yes.
So, a specific date may kindly be given
that
from this honorable court.
We have also filed a revisional application, which is appearing in your lordship's list arising out of the same different portion of the same impugned order. That is appearing as item number 147 today.
Let both of them be taken together.
Taken
Lordship.
together.
Yes, Lordship, this my application. Lordship, the plaintiff is the petitioner before your Lordship. I filed a suit for declaration of my title, recovery of possession and injunction, Lordship. There, Lordship, I filed an application under Order 39, Rule 7. That was allowed. And an advocate commissioner was appointed. She inspected the property and submitted a report. Now, Lordship, we wanted to mark that report as an exhibit. But in the meantime, that lady advocate, she got married and her matrimonial home was in Delhi. So she shifted to Delhi. But at that point, when we wanted to get that report marked as exhibit, the other side, the defendants took an objection that it cannot be marked as an exhibit in the absence of that learned advocate commissioner. So, Lordship, the court granted me liberty to produce that advocate commissioner as a witness virtually. Now, and Lordship, the date was fixed on 23rd of December. Now, on 23rd of December, Lordship, we filed an adjournment petition saying that she was not available. And Lordship, a last chance was given on 7th of January. On 7th of January, Lordship, we also sought for an adjournment on the ground that she was undergoing some treatment, Lordship, in Delhi. So it was not possible for her to appear virtually. On that day, the learned trial judge, Lordship, closed her evidence. So challenging that order, Lordship, that is the first order which we challenged. And Lordship, thereafter, after that, DW's evidence was also concluded. We filed a recalling application of the 7th January order and praying to recall that order along with another application under Order 26 Rule 10 so that either the advocate may be given an opportunity to adduce evidence virtually or some advocate may be appointed who will go and take her evidence. But both were rejected. So this is my revision. Now, Lordship will first kindly come to page 34. This is order number 50, Lordship. Yes. Lordship kindly sees the 4th paragraph. Learned advocate for the plaintiff submitted that the local inspection report submitted on January 29 by the learned commissioner Pushpita Mukherjee should be marked as exhibit. As at present, she is unable to appear before this court and depose as she is residing in Noida, Delhi. It is also submitted that the local inspection report is necessary for adjudication of this case and therefore being a part of record, it is required to be admitted in evidence and the same should be marked as an exhibit in the instant suit. Now, the learned advocate for the defendant raises objection, though no written objection has been filed against the instant application and submits that there is no provision in law to mark the local inspection report exhibit without examining the maker of the document and therefore the present petition should be rejected with cost. So on this day, Lordship kindly sees the third last paragraph. Learned advocate commissioner, namely Pushpita Mukherjee, is directed to virtually appear before this court and adduce her evidence to VC on the next date fixed. Learned advocate for the plaintiff is directed to communicate this order to the learned advocate commissioner. And Lordship, 23rd of December was for PW3 through VC. Now, Lordship, on the next, that is on 23rd of December, yes. Lordship kindly sees the order sheet. I have annexed it, the original order sheet, the certified copy. Yes. No, first on Lordship on 7th January. That is my first impugned order, Lordship. May I place it? Yes. Yes. Order number 52. The learned advocate for the plaintiff filed a petition praying for time for PW3. Yes. Lordship, I have also annexed the adjournment petition, Lordship. That is at page 35. Yes. Kindly see paragraph 2. that thereafter the plaintiff has duly communicated the said order to the said learned advocate commissioner such and such for this reason. So after 7th of January, Lordship, the evidence of the defendants began. Thereafter, Lordship, I filed 2 applications. One for modification of order number 52 dated 7th of January for recalling that order, and Lordship also another application under order 26 rule 10. Lordship, those application, first application is at page 36. Yes. And the prayer, Lordship, is at 37. My prayer was, it is therefore, here, Lordship, in paragraph 5, I have stated that now she has recovered and she is ready to adduce her evidence through VC. Though it has been mentioned plaintiff, it is not the plaintiff, the commissioner. And so my prayer at page 37 and 38 is, it is therefore prayed that the learned court may be pleased to appoint an advocate commissioner practicing in this court who will take deposition commission of the said advocate at the present residence of, yes, yes, yes. And Lordship, another application I made at page 39, it is the modification of the 7th January order. My prayer was at page 40, Lordship. It is therefore prayed that the learned court may be pleased to modify the aforesaid order by recalling the same for the interest of justice and fair play by giving an opportunity to adduce the evidence of the learned commissioner through virtually or by deposition, commission by appointing advocate commissioner from this court who will take deposition. Yes. Yes. Yes, yes. In whatever manner, either through commissioner or virtually. Now, Lordship, by the second impugned order, that is order number 59, dated 24th of February 2025, both these applications were rejected. Now, this order has 2 parts, Lordship. The first part has been challenged by my learned friend in the second revisional application. Now, Lordship will kindly come to the second last paragraph in the first page. Now, the petition for modification. Your Lordship has got it? So, the learned advocate for the plaintiff submitted that the local inspection commissioner who was practicing advocate of this court is at present residing at Noida, New Delhi, and therefore her evidence should be taken through VC as per the order of this court being number 50 dated such and such, as she is suffering from such and such. Alternatively, the learned advocate for the plaintiff also prayed for appointing deposition commissioner for deposition of the learned advocate commissioner who conducted local inspection in the instant case on the aforesaid ground so that the inspection report may be marked as exhibit. By submitting the above, the learned advocate for the plaintiff prayed for allowing the instant petitions. The learned advocate for the defendant raised a strong objection and submitted that this court has no scope to consider the instant application at this stage when the DW is already over. As such, the learned advocate for the defendant prays for rejection of the instant petitions with cost. Heard the learned advocates on careful perusal of the record, it appears that the learned advocate for the plaintiff was repeatedly taking time for evidence of the learned commissioner since 19/6/2024 on the ground that she is at present not available at Durgapur court. Subsequently, when the court fixed for the evidence of the learned advocate as a special chance in default clause on 6/11/24, one application was placed for marking the local inspection report as exhibit in absence of the learned advocate commissioner. And at that time of disposal of the said petition, the court, considering the facts and circumstances of the case, vide such and such, permitted the evidence of learned commissioner. However, even after granting such opportunity, the plaintiff has failed to avail the same, for which PW through VC as last chance in default clause was fixed by this court on 23rd of December 2024. Subsequently, vide order number 52 dated 7th of January 2025, this court closed the said opportunity. At present, the learned advocate for the plaintiff wants to reopen the said PW3 without any justifiable cause as to why, in spite of granting series of dates, he failed to avail the same. Moreover, at present, no medical documents of the learned commissioner came before this court as stated in the instant petition. As such, in light of the above discussion, Lordship, both were rejected. So, Lordship, I have clearly stated that, Lordship, the Advocate Commission. Lordship, the nature of illness your Lordship has seen, she didn't want to, Lordship, place those on records. But she has those documents. If your Lordship so wants, I can bring it.
Lordship, this. Yes. No, in my respectful submission, that will not be the correct thing to do. But what played before the learned trial court's mind, in the learned court's mind, if your Lordship kindly sees these orders, your Lordship will find the evidence what I have. I give a copy to your Lordship. This is the entire order sheet as printed out from the server. I'm handing over a copy to my learned senior friend. The Lordship will find this is from order number 36 dated 22nd of November 2022. And the last order is order number 48 of 6th of November 2024. Just prior to the orders in the annex to the revisional application, Lordship will find only one effective evidence, that is order number 45 dated 8th of April 2024. That is the only date when an evidence was taken. All the other orders are time taken by the plaintiffs or the bar was closed. So this was the conduct which prompted the learned trial court to pass this order. Enough opportunity was granted. Yes. That will not to revisit, but that should be taken into consideration while. Absolutely. No, not that. But it was a continuous conduct of the plaintiff which prompted the learned trial court to take a harsh decision.
Yes, we shall produce, Lordship. Yes, yes.
And my challenge is with regard to the first portion of 24th of February order. So Lordship can take this revisional application only because the impugned order is there. The Lordship will kindly take. Not only that, that was your Lordship observed that in the last order. Not only that, your Lordship will find that they filed an application of certain certified copies they wanted to mark as exhibit. That application was allowed simultaneously without recalling the witness. All those documents were marked as exhibits. Those were certified copies. The procedure that was not there was no application for recalling of any witness. Nothing was there. The prayer was also not there. Only the prayer was that let these documents be marked exhibit, and the learned trial court proceeded to mark those documents as exhibits.
Lordship kindly sees what objection they gave at that time. Lordship kindly sees in the middle portion.
That was my contention, that that application was filed on that day and no objection.
Yes. Yes. No, Lordship, the court has also recorded that also. Lordship kindly sees, let me place Lordship from the middle portion. Yes, because that was also their objection. Lordship kindly sees. Learned advocate for the defendant raised formal objection and submitted, that was their submission, that this court can took a look of that said documents at the time of passing of the final judgment. Now, Lordship, when a document is marked as an exhibit, Lordship, various types of objections can be taken. One is that the first thing is, Lordship, Lordship, these documents are based on their title. Lordship kindly sees from the first, Lordship, the learned advocate for the plaintiff submits that during cross-examination of DW1, he has stated that the entire suit property was owned by Babulal, who purchased the same by deed of sale number of 64, 2 deeds of 64. And thereafter, he sold the same to Niranjan Dotto, Vide, sale deed number 1973, and to Dhirendra Nath, Vide, sale deed number of 1973. And to Srimati Rita Rani, Vide 73. It is submitted by the learned advocate for the plaintiff that the defendant, having knowledge of the same, never filed the aforesaid documents before this court, and they have obtained certified copy of the same, and the same were not within the custody or knowledge of the plaintiff. So, Lordship, these deeds which I now sought to prove is their admitted documents through which they have purchased the property. Yes, true. Then Lordship kindly grants us liberty that we will call, because Lordship, these documents, only Lordship, the person from the registry office, they will come and state that we have obtained certified copy of
They
that.
have to tender it into evidence. Thereafter, the question of proving that document comes.
Proof
Whether that is a certified copy. Whether those are the
Because
certified
these
copies,
are
that
their
has to be proved.
documents, and in their evidence, they have stated these deed numbers. It is not their case that the deed numbers which they have stated, then Lordship kindly grants me liberty for that.
Lordship, in the year 2002, my predecessor filed the WS by stating some statement, some paragraphs, Lordship. I have the incorporated subsequent events that the club is there since 1970, and subsequent events like the club is now getting the grant from government, and they are working with the people over there and making construction for swimming pool and for playground, and all these things are there, Lordship. Nothing, no new things, nothing is there, new things has been incorporated, and not it will relevant for Lordship. This is the club is old one, Lordship, and I came here. I am the newly added defendant number 2, Lordship, in the court below. Substituted, not Lordship, substituted. They have filed one amendment application, and where they have added me. Yes, Lordship. And that has been, Lordship, here is the application. Lordship. Order. 14. Yes, Lordship. Substituted, Lordship. Substitution has been filed for addition of the plaintiff, Lordship, where they by amendment petition they have been added me, Lordship. Lordship, here is my copy of the order, Lordship, that shows that summons should be served upon me. And Lordship, it is the application copy where I have been added. I came into the scenario, Lordship, in the year after 2024, Lordship, and delay was not by my part. Yes, Lordship. Yes, I came here afterwards. But Lordship, the court below, directed me to appear and file WS, Lordship. I was not there. It's their suit. The suit is there, Lordship. Lordship, I am incorporating only certain things which is not change the character, nature and character of the suit, Lordship. If I fail to incorporate those, I am the present president, Lordship. I need to what are the development I should incorporate in my suit? Otherwise, my appeal will. Otherwise, my evidence will struck off, Lordship. My evidence is going on in the court below, Lordship. In default, they will close my evidence. Tomorrow is the date fixed. Kindly allow me to incorporate certain things, sir. There is something. The present thing is not there. My application, Lordship, the subsequent facts is there, Lordship. Yes, Lordship. Lordship, I have added after in the stage of evidence, Lordship. I was not there. But I came afterwards, Lordship. I was not there. They have added me in the presently, Lordship. Kindly consider that so that I can incorporate subsequent things, Lordship. The club is growing, Lordship, and it will not harm the suit suit. No, Lordship. I appear, Lordship. Kindly consider. I appear in the year 2000 after 2024, Lordship. It is not fault on my part, Lordship. They have substituted, Lordship. One thing, Lordship. The earlier Lordship, one thing. Earlier president has been died in the year 2029, and they have amended us after 2024, Lordship. It was not our fault. So kindly allow me to incorporate my so that my evidence not struck off. Lordship, let me serve and come back, Lordship. Let me serve and come back. And limited stage. one day, Lord, tomorrow is the date fixed for, and serve and come.
ये देखिए तो आवाज क्यों बंद हो गया?
Experience disposal. Yes, my method. No, no, बोल तो fast matter. Well, this is very simple thing. JPK Metallic Private Limited. This is the present company. And previously, well, here is the affidavit of service. On the last occasion, the Lordship Justice Sampasarkar directed me to serve copies upon the state collector. What happened? I am telling you, Lordship. My Lord, KPA Securities Private Limited, practically land was acquired by the government and it was decreed, it was award was given against that section 18, my Lord. The district judge
ये
also,
एक मिनट देखिए क्या बोल रहा है ये?
district judge enhanced the amount. In the meantime, and we are also directed to take the check in the name of KPA Securities Private Limited. By this time, what happened? My Lord, this company, existing company has been defunct. The same company having same permanent account PAN card number, this has been functioned, and the certificate by the Registrar of Companies Calcutta under Ministry of Company Affairs has been given. I am producing. Now, my Lord, in these circumstances, we require an amendment to the concerned code for amendment of the degree, because that company is now should be written as such and such, because their liabilities and everything has been same PAN card, same everything, same director, same address, everything. Now, unfortunately, my Lord, the learned judge in the court below probably was not advancing with the civil affair. He was, my Lord, we are not allowed even to file the application for amendment. No, that has been disposed of. I can do. All right, whatever you take it and get it rejected. Even we got the bench clerk not to accept the application. So you had to come before your lordship. And on the last occasion, his lordship, my lord, directed me to serve copies upon the collector. Practically, they have got nothing to do. If I am allowed, my lord, to place before your lordship the documents for which I have come. Yes, my lord, again. Well, kindly fix the date so that
Now, today is also the matter is pending at the argument stage and nobody is available in the particular court and the PO who is in charge is not taking up this particular matter. And for the last 7 months, Malak, I am the plaintiff in the particular suit. Malak, no, Malak, for the last 7 months, this particular suit was not even entertained by any person, and that particular suit, the argument is pending at my instance. Malak, kindly let there be direction for the speedy disposal. That's it.
I'm appealing for the petitioner. Suit is of 2011. Milord, my 7-2 application is pending from 2011. Milord, and Milord, my order 6-17 is also pending. And Milord, next date is being now Milord posted in July, 27 July. Well, I would humbly beseech my lord to direct this 7-2 and my order 6-17 because now 2G has crept in. My lord, six after more than 1 year. And on that date, even also matter as adjourned, and next date is fixed on my lord in September 23rd September, my lord 2026. That is the reason, my lord. Date is fixed after more. My lord.
Recovery of money amounting to 4 crores. Defendants are taking adjournments for more than 10 occasions, filing frivolous applications. After that, after 2 to 3 dates, they are withdrawing. Yes, my 2024 suit, Lordship will already PW1 has been started. Lordship will kindly seize, my lord. This is the last date for my lord. But only I am seeking, my lord, 2 prayers before Lordship, my lord. Let PW1, my lord, his witness may be completed within 2 months because, my lord, a surgery is going to be held, my lord, recently, my lord. And second thing is that, my lord, they are making everyday frivolous applications. After that, they are making, my lord, not pressed. My Lordship can seize the order, my lord. But only, my lord, Lordship will kindly, my lord, time frame in respect to the PW1 is concerned. That I will. But when PW1 already started, it has been already started. So Lordship will fix it a date, day by day to day. No. Let that be completed within a stipulated period of time. Only I am seeking that. I'll make an again the other side will come and give an objection. That will your Lordship knows much better than me. Lordship already PW. Very well. My PW1 witness may be completed within a stipulated period of time. Already PW. Well, I know the Sujma already PW1 has been started. Lordship will kindly seize. Well, I have not filed, but the defendant have filed this application. Lordship will kindly seize the order, my lord. Order 1, Rule 10, file, my lord, for 6 occasions. Yes, I have filed, my lord. Lordship will kindly seize, my lord. No. My if my witness is done, my lord, only I am seeking for my witness may be completed. No. My lord, what is happening, my lord? No, I'm not pressurizing them, my lord. Then my Lordship will kindly, as well as the witness has started, that within 1 year of the very well, my Lordship will get. One year, 6 months. 6 months.
My lord, I beg to appear for the defendant petitioners, my lord. My lord, the partition suit was filed in the year 2022, my lord, by the opposite parties. And my lord, in order number 90, beg your pardon, in order number 18, my lord, the application under order 39, rule 1 and 2, my lord, disposed of. My lord, I'm suffering from the order of injunction, my lord. My lord, in order number 21 for SRAT, my lord, next date was fixed on 12th of January 2026. On 12th of January, my lord, next date is fixed on 6th of May for SRAT appearance, my lord. This is the present situation, my lord, since 2022. My
It is a succession case, my lord, of my lord 2022. The argument was done in July 2023. Since then, the judgment has not been passed. Then, my lord, only the argument may be, my lord, the only thing the learned trial court says that the predecessor in no, my lord, the court is there. I am appearing there. Same judge is there who heard the argument. Only at the SRAD stage, some signatures were not done. That is why, my lord, since 2 years, the learned court has not passed the judgment. My lord, I am agreeable to do the argument again, my lord. Very short matter. Only mother's property kept in locker, LA of the same, letter of administration. And also, my lord, the certified copy was not given. I submitted representation. The district judge Alipur has communicated that wait for some time. Very simple matter, my lord. Languishing for so much time. The commission work was done. Commissioner's report was filed. My lord, kindly see page number 9. It is the e-court extract, my lord. On 15th of July 2023. It was hard. Argument was done. And since 16th of August, the order, dates are being fixed for. Yes, my lord. On 6th of May, when I mentioned the matter before the learned court has fixed the matter for argument, but has not heard the argument. My lord, the learned court is in session. She is there, not transferred, but still the argument is not heard, and also the judgment is not part. I am agreeable to do the argument again. But my lord, there has to be the judgment. Very simple matter, my lord. Only pertaining to a locker. And there is no other heir, that is why no other opposite party. My lord, the next matter is also mine. No, my lord. The separate suit, my lord, separate court. A different court. My lord, one indulgence, my lord, from tomorrow, my lord, I will be in the circuit bench, my lord. This is very hard for me. My lord, it is a 2019 suit, my lord. Till date, the injunction application has not been heard and not disposed of. The interim injunction is there.
Yes. Milord, not tomorrow. Tomorrow, Milord, I will be out of station. Except day after tomorrow. I'm grateful.
I don't know, 210 already passed order. 210 listed manner, wrongly manner, your lordship already passed on 2nd April manner, 210. Manner that has your lordship wrongly listed manner. Wrongly.
My lord.
Your lordship already passed order on 2nd.
My lord, I am mentioning item number 226, my lord. It was wrongly printed. Matter is appearing.
Madam, the plaintiff number 3 and 5, my lord, died. My lord, the substitution application, my lord.
I am for the petition.
Yes, my lord. Substitution application has been filed. My lord, beyond time. That was allowed by the court. My submission would be, the entire suit would not have it. That's why the substitution application has been allowed.
Two petitioner died, my lord.
Yes, we have served, my lord. Affidavit of service, my lord.
Lord, the order impugned, my lord, is as regards to, my lord, the issue involved in the civil revision, my lord, as to whether by way of amendment. Yes, it was lastly extended, my lord, by an order dated 3rd December 2025 for 4 months, my lord. We have filed the application, my lord, in the month of March. Yes. Yes, ma'am. Yes.
So, all right, my lords. All right, my lords, certain similar matters are listed on 22nd. Very well, ma'am.
First, may I return the motion? Item for 100. We give that has to be informed to the opposite party after having the notice. They started digging operation for physical. So, we have solved so effective. The item number 100. This next.
224. I am appearing for 225.
224. And for the petitioner, my lord. This is affidavit of service.
This matter, I have the instruction to appear on behalf of the opposite parties.
My lord, it was lastly allowed on 24th December.
Let it be extended, but I do not have any objection for a limited period. Man. Grateful to you.
My lord will be kindly.
My lord, I am appearing for the petitioner. My lord, it's an application for extension of interim order. Copy has been served, my lord, for CAN as well as the main application. Both the affidavits may kindly be taken on record. First extension filed within time. Within time.
Seven.